when the objectives of the conspiracy
Get money,
or
gang.
the agreement that they be
We
fulfilled
live.
is abandoned by the person and by those with whom the person conspires. The objectives of the conspiracy include, but are not limited to, escape from the offense, distribution of the proceeds of the offense, and measures other than silence for concealing the crime or obstructing justice in relation to it. Abandonment of a conspiracy is presumed if neither the person nor anyone with whom the person conspired does any overt act in pursuance of the conspiracy during the applicable period of limitation. If an individual abandons the agreement, the conspiracy is terminated as to that person only if and when the person advises those with whom the person conspired of the abandonment, or the person informs law enforcement authorities of the existence of the conspiracy and of the person's participation therein. However, mere presence is not sufficient to support a conviction. Facilitation to wit, conspiracy to commit first-degree murder. Any person who commits the offense of facilitation to wit,
Hit that like
conspiracy to
button. Hit
commit
that
first-degree
subscribe
murder
button.
is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of conspiracy to commit first-degree murder, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the conspiracy, and that the defendant furnished such assistance knowingly. Conspiracy to commit first-degree murder has been defined on page 4. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or the circumstances, or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable in count 2 in this indictment. First-degree murder. Any person who commits the offense of first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and the defendant acted intentionally. A person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim, Adolph Thornton Jr., and that the killing was premeditated. A premeditated act is one done after the exercise of reflection and judgment. Premeditation means that the intent to kill must have been formed prior to the act itself. It is not necessary that the purpose to kill pre-exists in the mind of the accused for any definite period of time. The mental state of the accused at the time he allegedly decided to kill must be carefully considered in order to determine whether the accused was sufficiently free from excitement and passion as to be capable of premeditation. If the design to kill was formed with premeditation, it is immaterial that the accused may have been in a state of passion or excitement when the design was carried into effect. Furthermore, premeditation can be found if the decision to kill is first formed during the heat of passion, but the accused commits the act after the passion has subsided. Second-degree murder. Any person who commits second-degree murder is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted knowingly. Knowingly means a person acts an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Facilitation to wit, first-degree murder. Any person who commits the offense of facilitation to wit, first-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of first-degree murder, but did not.
Life doesn't stop when you're getting an education. That's why Sophia offers self-paced, online, college-level courses that are designed to transfer. Access 60-plus courses for only $99 a month.
Bang, bang, bang.
And that the defendant furnished substantial assistance to that person in the commission of the first-degree murder, and that the defendant furnished such assistance knowingly. First-degree murder has been defined on page 8. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, second-degree murder. Any person who commits the offense of facilitation to wit, second-degree murder is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of second-degree murder, but did not have the intent to promote or assist the commission of the offense or to benefit from the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the second-degree murder, and that the defendant furnished such assistance knowingly. Second-degree murder has been defined on page 9. Knowingly means that the person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Voluntary manslaughter. Any person who commits voluntary manslaughter is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant unlawfully killed the alleged victim, Adolph Thornton Jr., and that the defendant acted intentionally or knowingly, and that the killing resulted from a state of passion produced by adequate provocation from the alleged victim, sufficient to lead a reasonable person to act in an irrational manner. Passion means any of the human emotions known as anger, rage, sudden resentment, terror, or similar emotions, which renders the mind incapable of cool reflection. Knowingly means that a person acts with an awareness that his conduct is reasonably certain to cause the death of the alleged victim. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally when it is the person's conscious objective or desire to cause the death of the alleged victim. The distinction between voluntary manslaughter and second-degree murder is that voluntary manslaughter requires that the killing result from a state of passion produced by adequate provocation from the alleged victim sufficient to lead a reasonable person to act in an irrational manner. Aggravated assault. Any person who commits the offense of aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant intentionally or knowingly caused bodily injury to another, and that the act resulted in the death of another. Bodily injury includes a cut, abrasion, bruise, burn, or disfigurement, and physical pain or temporary illness or impairment of the function of a bodily member, organ, or mental faculty. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Facilitation to wit, voluntary manslaughter. Any person who commits the offense of facilitation to wit, voluntary manslaughter, is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of voluntary manslaughter, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the voluntary manslaughter, and that the defendant furnished each such assistance knowingly. Voluntary manslaughter has been defined on page 13. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Any person who, facilitation to wit, aggravated assault. Any person who commits the offense of facilitation to wit, aggravated assault is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of aggravated assault, but did not have the intent to promote or assist the commission of the offense or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the aggravated assault, and that the defendant furnished such assistance knowingly. Aggravated assault has been defined on page 14. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it
She
is the
breaking
person's
down,
conscious objective
she
or
giving
desire
out
to
the
engage
rules
in the conduct
on
or
what
cause the result.
crimes he
Simple
actually gonna
assault.
be guilty for. It's
Any
certain
person who
rules they
commits a
have to
simple
go by the
assault upon
jury.
another is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond.
That's why when you doing crimes
You take a bench trial because they know the law. She have to sit there and teach them the law so they could know. And then they be kind of pushing you in one direction. Y'all ever had jury duty? They be wanting you to say and pick, you know what I'm saying? They not going to pick you if you got your own mind. You feel me?
A reasonable doubt the existence of the following essential elements: that the defendant caused bodily injury to another, and that the defendant acted either intentionally, knowingly, or recklessly. Facilitation to wit, simple assault. Any person who commits the offense of facilitation to wit, simple assault is guilty of a crime. For you to find a defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant knew that another person intended to commit the specific offense of simple assault, but did not have the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, and that the defendant furnished substantial assistance to that person in the commission of the simple assault, and that the defendant furnished such assistance knowingly. Simple assault has been defined on page 18. Knowingly means that a person acts knowingly with respect to the conduct or to the circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. The requirement of knowingly is also established if it is shown that the defendant acted intentionally. Intent means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. The court will now explain to you the law applicable to count 3 in this indictment. Convicted felon in possession of a firearm. Any person having been convicted of one of certain specific felonies who possesses a firearm is guilty of a crime. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements: that the defendant had been convicted of a specified felony, and that the defendant, after such felony conviction, possessed a firearm, and that the defendant acted either intentionally, knowingly, or recklessly. Firearm means any weapon that will
hit that like button, bro. I'm playing with my channel, fam.
By the action of an explosive.
And share this to your Twitter,
Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to a result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or the result will occur. The risk must be of such a nature and degree.
Guess who's back? Me. I'm back. The Kelly Clarkson Show. It's a new season. It's bright, it's fun, it's new. I like it. It's a new season.
I love the racks. Racks on racks on racks on racks on racks. I love the third.
Hold on, y'all. Hey, that'll give you a
Evidence is those parts of the testimony admitted in court which refer to what happened and was testified to by witnesses who saw or heard or otherwise sensed what happened firsthand. If witnesses testified about what they themselves saw or heard or otherwise sensed, they presented direct evidence. Circumstantial evidence is all the testimony and exhibits which
That Tops barbecue almost killed me in Memphis. That shit gave me food poisoning. It felt like I was finna die in that bitch.
Give you clues about what happened in an indirect way. It consists of all the evidence, which is not direct evidence. Do not assume that direct evidence is always better than circumstantial evidence. According to our laws, direct evidence is not necessarily better than circumstantial evidence. Either type of evidence can prove a fact if it is convincing enough. A defendant may be convicted on direct evidence, circumstantial evidence, or both. Accomplice. The prosecution has presented a witness who claims to have been a participant with the defendant in the crime charged. While you may convict upon this testimony alone, you should act upon it with great caution. Give it careful examination in light of other evidence in the case. You are not to convict upon this testimony alone unless you are convinced beyond a reasonable doubt that it is true. Credibility of witnesses. You are the exclusive judges of the credibility of the witnesses and the weight to be given to their testimony. You should consider all the evidence presented in this case by the state and by the defendant
right here,
full, fair, and impartial consideration. Part of your responsibility is to determine what the facts are based on what you heard from the witnesses. If there are conflicts in the testimony of different witnesses, it is your duty to reconcile them if you can, for the law presumes that every witness has told the truth. But when you cannot reconcile the statements of different witnesses, then you must decide which witness or witnesses you believe and how important his or her testimony was. You do not have to accept or reject everything a witness said. You are free to.
I'm gonna tell you something. With dudes snitching, and I told y'all Justin Johnson's best thing is to be quiet and don't testify, because a real lawyer could say, man, bro, it's a possibility he the one who said it. Jook ain't there. Straight drop really could get off on this, because he could say, man, dude putting the story, who would say that he's not the main character? They're putting it all on me. See, that's how he could beat it. His lawyer could beat that.
Believe all, none, or part of any person's testimony. In forming your opinion as to which witness you believe, you may consider the following factors: how the witness looked, acted, and whether the witness appeared to you to be telling the truth when he or she testified. Was the witness able to see or hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Whether the witness was in a position to know about the matter to which he or she testified. In other words, how well could the witness see or hear what he or she testified he or she saw or heard? Whether the witness's statements were consistent and how believable the statements were. Whether the witness had a motive to testify truthfully or to testify untruthfully. And any proof presented of the witness's reputation for telling the truth. All in all, how reasonable does the witness's testimony seem when you think about all the other evidence in the case? Another factor for you to consider in evaluating a witness's testimony is whether the witness has made material statements at some point before he or she testified, which are different from his or her testimony at trial. However, unless entered as a numbered exhibit by the court and allowed to be taken by you back to the jury room when you deliberate, proof of any prior different statement may be considered by you only for the purpose of determining if the witness is telling the truth at trial. The contents of the prior inconsistent statement are not to be considered as proof.
You don't want snitching. I don't.
Another factor for you to consider in evaluating a witness's testimony is whether the witness's testimony during cross-examination appeared to be contradictory, unreasonable, and improbable.
He could come back on appeal or something. There's some flaw in this case now. I thought about it. I sat there and thought. There's some flaw in the case. Because I thought about the time when this nigga snitched on me I'm thinking about the time this nigga snitched on me, and my lawyer took it like, man, bro, he could have put that right there. You know what I'm saying?
May be charged
So
with
that's
the
what I'm
commission
thinking
of the
about.
offense.
My experience.
The defendant is criminally
I'm an
responsible for an offense
criminal. You
committed by the conduct of
Yeah.
another if acting with the intent to promote or assist the commission of the offense, or to benefit in the proceeds or results of the offense, the defendant solicits, directs, aids, or attempts to aid another person to commit the offense. Intent means that the person acts intentionally with respect to the nature of the conduct or to the results of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. To find a defendant criminally responsible for the acts of another, it is not necessary that you find the defendant was present or that the defendant took a physical part in the crime. Encouragement of the principal offender is sufficient. However, mere presence during the commission of the offense is not sufficient to support a conviction. Absent material witness. When it is within the power of the state or the defendant to produce a witness who possesses peculiar knowledge concerning facts essential to that party's contention and who is available to one side at the exclusion of the other, and the party to whom the witness is available fails to call such witness, an inference arises that the testimony of such witness would have been unfavorable to the side that should have called or produced such witness. Whether there was such a witness and whether such an inference has arisen is for you to decide, and if so, you are to determine what weight it shall be given. This inference does not apply to the defendant because he has a lawful right not to testify, and his failure to testify cannot be considered for any purpose against him, nor can any inference be drawn from such facts. Defendant not testifying. The defendant has not taken the stand to testify as a witness, but you shall place no significance on this fact. The defendant is presumed innocent, and the burden is on the state to prove his guilt beyond a reasonable doubt. He is not required to take the stand in his own behalf, and his election not to do so cannot be considered for any purpose against him, nor can any inference be drawn from such fact. Stipulation. A stipulation is an agreement between the parties. The parties have stipulated that certain matters of fact are true. They are bound by this agreement, and in your consideration of the evidence, you are to treat these facts as proved. The parties have entered into two stipulations. The parties have stipulated that Adolph Thornton Jr. was a living person who is now deceased, and an autopsy was performed to substantiate these facts. The parties have also stipulated to the fact that the defendant, Justin Johnson, is a convicted felon, previously convicted on May 2nd of 2017 in Division 8 of the Criminal Court of Shelby County. Flight. The flight of a person accused of a crime is a circumstance which, when considered with all the facts of the case, may justify an inference of guilt. Flight is the voluntary withdrawal of oneself for the purpose of evading arrest or prosecution for the crime charged. Whether the evidence presented proves beyond a reasonable doubt that the defendant fled is a question for your determination. The law makes no precise distinction as to the manner or method of flight. It may be open, or it may be hurried or concealed departure, or it may be a concealment within the jurisdiction. However, it takes both a leaving the scene of the difficulty and a subsequent hiding out, evasion, or concealment in the community or leaving of the community.
I don't want to hear nothing about no Tops barbecue. That shit almost killed me, man. I don't want to hear nothing about no Tops barbecue this morning.
Or parts unknown to constitute flight. If flight is proved, the fact of flight alone does not allow you to find that the defendant is guilty of the crime alleged. However, since flight by a defendant may be caused by a consciousness of guilt, you may consider the fact of flight. If flight is so proven, together with all the other evidence when you decide the guilt or innocence of the defendant. On the other hand, an entirely innocent person may take flight, and such flight may be explained by proof offered or by facts and circumstances of the case. Whether there was flight by the defendant, the reasons for it, and the weight to be given to it are questions for you to determine. Multiple counts, finding of each required. The crime charged in each count of the indictment is a separate and distinct offense. You must decide each charge separately on the evidence and the law applicable to it. The defendant may be found guilty or not guilty of any or all of the offenses charged. Your finding as to each crime charged must be stated in your verdict. Jury deliberation and unanimous verdict. The verdicts must represent the considered judgment of each juror. In order to return a verdict, it is necessary that each juror agree thereto. Your verdicts must be unanimous. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Notes. If you have been taking notes in this case, these notes are for your individual use only, and you should not use your notes directly or indirectly, explicitly or implicitly to persuade other jurors as to the accuracy of your notes. They should not be shown to others, nor compared, nor referred to in any way as authority, but should be used privately only by you as an aid to your individual memory. Deliberation, order of consideration. In reaching your verdict, you should first consider the offense charged in the indictment. If you unanimously find the defendant guilty of that offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense. If you unanimously find the defendant not guilty of that offense or have a reasonable doubt of the defendant's guilt of that offense, you shall then proceed to consider whether or not the defendant is guilty of the next lesser included offense in order from greatest to least within that count. You shall not proceed to consider any lesser included offense until you have first made a unanimous determination that the defendant is not guilty of the immediately preceding greater offense, or you unanimously have a reasonable doubt of the defendant's guilt of that offense. If you have a reasonable doubt of the guilt of the defendant as to all offenses charged and included in that count, you shall return a verdict of not guilty and proceed to the next count. That is the law, ladies and gentlemen. We will now proceed with closing arguments.
Good morning.
Good morning.
So it's almost over, and I'm sure you all are happy. My name is Iris Williams. I'm one of the prosecutors on this case. And earlier this week, you heard opening statements.
Hit that like button, drop a comment. Don't come up in here without talking, Joe.
You were told all
Playing with me on my channel.
And one of those important
Gotta
things
get
that
this
you
channel busted like my
that it is
first
not
channel.
1981, and that things have changed. But what does that mean? It means that it's hard to keep a secret. It's hard to hide who you're talking to. It's harder to hide your actions. And it's even harder to hide who you know. But ladies and gentlemen, despite all of those things that have changed, one thing has not changed, and that is the state's burden. The state's burden of proof is beyond a reasonable doubt. So what does that mean? Where are we? So the defendant, Justin Johnson, is charged with 3 counts: conspiracy to commit first-degree murder, and convicted felon in possession of a firearm. So I know that you've already gone through a little bit of this law during voir dire, and especially through the jury instructions. But a brief overview of conspiracy to commit first-degree murder is that 1, this defendant entered into an agreement with 1 or more people to commit first-degree murder. 2, each of the parties to the conspiracy had the intent to commit the first-degree murder. 3, each party acted for the purpose of promoting or facilitating the first-degree murder. And 4, 1 or more of the parties committed an overt act to help the crime happen. So what did we hear this week? This week we heard testimony from co-defendant Cornelius Smith. He testified for us and he told us that he met Justin Johnson through Hernandez Golan, and that he knew.
You gotta watch this shit, man. We ain't trying to get no copyright. You gotta watch this shit. You hear me? We gonna be the coldest niggas that ever touched, though. You hear me? Yeah, that's the problem, man. Motherfuckers think that shit sweet. Hey.
Not only did he tell us that,
I'm on
he
pause.
told us that this plan had been.
Remember, this was 3 years ago, almost 21. Yeah, that was 3 full. November make 3 full years. Technology done went crazier than that in 3 years. They had cameras everywhere 3 years ago. Cameras been everywhere. Then they got the Ring cameras. People got little cameras on their houses. Tesla's got cameras on their cars. All the stuff is just coming. They just starting to use it and it's coming to the light. This stuff been out here. This stuff just ain't wake up. How long? I remember seeing Tesla cars in like 2014 or 15. That truck, I wanted that truck because I used to be racing them. They be burning my ass. Technology been out for over 10 years. This the age.
In process for weeks, and that Justin knew about it. And there were conversations previously or prior to this murder, and Justin Johnson was an active participant in those agreements. So there we have it, a conspiracy to commit first-degree murder. An agreement was made. Each of the parties had the intent to commit the first-degree murder. Each person acted for the purposes of promoting, facilitating, and, ladies and gentlemen, the overt act is the killing. Next, first-degree murder. In essence, a first-degree murder is a premeditated killing of another. What's required for first-degree murder is 1, that the defendant unlawfully killed the victim. The only way to lawfully kill someone is if you are in protection of yourself or others. Second, you have to prove that this defendant acted intentionally. Intentionally means that there was no mistake, there was no accident. Third, you have to prove that the killing was premeditated. And as we saw, or as we learned in voir dire last week, premeditation does not mean that you had to have this plan for months, weeks, or days in advance. It could just mean that you simply stepped out of your car. You held up your hand, you pointed a gun, and you shot and killed somebody. As long as you had a moment to think about what you were doing, that's premeditation. Next, so we heard from a couple of people this week. First, we heard from the victim's sister, Erica Thornton. She testified that the victim was a living person. He had a family, he had children. She's known him her entire life. She attended and planned his funeral service. And coupled with that, defense counsel and the prosecution agreed to a stipulation, which just means that they agreed to establish that this victim was a living person who is now deceased. Later on, we heard from Dr. Scantleberry. She was the medical examiner and performed the autopsy. she found that there was a total of 22 gunshot entry wounds, including gunshots to the back torso, front torso, head, neck, upper extremities, and vital organs. She also testified that on the property that was collected from the victim, there was no weapon. And we also heard from Raul Hawkins. He testified that he was head of Dolph security for years. He was able to identify Dolph's car in the beginning of the Makitas video, and he was also able to explain the difference between CMG and PRE, their history of conflict, rivalry, diss tracks, and even prior acts of violence that were towards Dolph. So with all of this testimony, we've established that there was a killing and that the victim was Adolph Thornton Jr. But was that killing unlawful? Was that killing premeditated? And was that killing intentional?
It was premeditated.
Back to Cornelia Smith. In addition to testifying about the agreement that he and the defendant entered into, he also testified about the killing. He said that on the day of the murder, the defendant picked him up from his father's house. They both knew that the victim was doing a turkey drive with several of his PRE artists. They also knew that Big Jook had a hit out on all of the PRE artists.
Oh, you want to know what I want to tell y'all? What hurt my heart? Because I was down there, bro. After this happened, and Dolph planned to bless everybody, and Dolph planned to give everybody a toy drive. They had a turkey giveaway. They had food, everything. They was giving away clothes, book, everything. Do you know, after that happened, do you know them brothers still went out there and handed out turkeys? They still gave out clothes. They still cooked and gave plates out. They still gave the kids toys. They still handed out coloring books, all that, man. After Dolph, I say, man, I wouldn't have been able to handle doing that, man. Them brothers are strong down there in Memphis. After Dolph, they still did their turkey drive. Shout out to Dolph now. The real Dolph now, PIE now. Shout out to them, man, because they stayed strong and they continue to do their turkey drive. I got the documentary in here, man. I'm telling you, it's about time to drop it now.
So it was their job that week to find them. And on November 17th, 2021, Cornelia Smith and Justin Johnson were on their way to a turkey drive in Westwood. As they were about to turn the corner, they saw a familiar car cross the intersection, which happened to be Dolph's car. Cornelius tells us that they followed the car, made a loop onto a back street, and then entered the Makita's parking lot. And this happened, I want to say, about 30 seconds after Dolph and his brother arrived at Makita's. Cornelius Smith was able to point out himself in that video and the defendant in that video. And he said that both of them were the shooting suspects in that video.
Listen to me. Straight Drop ain't said nothing. That guy snitch, a real lawyer with these closing arguments, it should dissect. I'm giving it, they ain't got to it yet, but I'm just giving you the head up. A real lawyer should be able to dissect that, because dude is putting everything on Straight Drop, Govin, everybody but him. And he did the most shooting. So that's his actions and him being honest about the crime is two different things. You could be thinking, what we talking about, how when they go to court, it's been 3 years. They not talking about how you thinking today or they thinking about how you was thinking 3 years ago. You hear me? You hear me? And dude, Justin Johnson ain't say nothing. His lawyer better go in there swinging, man. I'm telling you.
Video. The second suspect that got out of the car was wearing a black hoodie, gray pants, black shoes with white soles, and a Bass Pro hat. The same clothing that defendant Justin Johnson was seen in as he was exiting his apartments at the Crosstown Concourse. After the shooting.
Hey, C Hood might be on here. The case I was telling you about, my lawyer was like, damn, if he say that was his, shit, ain't it a possibility he could have put it in there? Or he could have put it under the seat. You feel me? So the lawyer got a chance with dude snitching. That's why it's always best to be quiet, gang. Let them do their job, G. They need to don't give them no. He gave them an exclusive investigation. No, they gotta do that shit themselves, bro.
Cornelius Smith testified that they got into the white Mercedes that they committed the act in. They went to Bradley Street. The defendant parked the white Mercedes on the yard, and they both got into a white Ford Expedition. They both got into that Expedition, and on the way, a couple of calls were made, right? Cornelius tells us that a FaceTime call was made to Big Joe. In that FaceTime call between Big Joe and our defendant spelled out the word Dolph. And as they were on their way to the Gospel Gardens apartment, the defendant also contacted a few other people who we'll find out later on. So once the defendant and Cornelius Johnson arrived at Gospel Gardens, they received wound care. They change their clothes, and then they go their separate ways. After they go their separate ways, Cornelius Smith tells us that he went to retrieve his phone, and he went to go wipe down the car, the white Mercedes that was parked at Bradley. So with Cornelius Smith's testimony, we have established that the killing was unlawful. There was no evidence to show that this defendant was in fear, was protecting himself, or was protecting someone else. We also established that it was intentional. It's not an accident. You didn't mistakenly follow someone's car into Nikita's parking lot and then shoot them. We also established that it was premeditated. They knew about this hit beforehand, and they committed this hit.
Y'all stay
So
tuned.
that
Y'all
wasn't
stick
enough
with
for
me,
you.
man. Don't be
We
coming
heard
in and
this
out. We watching this case this
We
morning.
heard from Kirsten Gardner. He testified that he was present during the time that the defendant was able to get possession of the white Mercedes that the act was committed in. Kirsten Gardner was at the Valero gas station in the early hours of November 17th, 2021. Next, let me go back to Kirsten Gardner. After he testified that, he told us that he didn't know anything about what was happening the next day, or a few hours after the cars were switched. Similarly, Jamarcus Johnson didn't know anything either. He just knew that he needed a ride. And his brother, Justin Johnson, could provide that for him. So he got his car, the rental car, and he took his cell phone, he fielded his calls, posted on his social media, and checked his emails. After Jamarcus Johnson, we heard from Sergeant Dabney. He was able to tell us about the 4 different bullet casings that were present at the murder scene. .40 caliber, attributable to a handgun. .762, attributable to an assault rifle that Cornelius Smith had. .223, attributable to a semi-automatic that Marcus Thornton probably would have had. And a 9mm casings found inside the store, which could be attributable to the handgun that Marcus Thornton had inside the store. That first one, though, the .40 caliber attributable to a handgun, was in the hand of the suspect with the Bass Pro hat. So, Sergeant Dabney also recovered the surveillance footage from Nikita's and Gospel Gardens showing this suspect in the same clothing that the defendant was in as he was leaving his apartment at 10:49 a.m. that morning. The timestamps on Gospel Garden and Nikita's coincide with the times defendant's phone accessed those towers. We heard from Special Agent Garner, who summarized that the defendant's phone accessed a tower that provided coverage to the Valero gas station at 3:17 a.m. Around the same time that Kissing Gardner said that he saw the defendant take possession of that white Mercedes at the Valero gas station. The defendant's phone also accessed towers that provided coverage for the area of 2370 Airways Boulevard, which is our murder scene. And it accessed those towers during the times of the murder, 12:22 p.m. to 12:23 p.m. on November 17th. Officer Garner also explained that the defendant's phone accessed a tower in the area of the 2-lane road in Shelby Drive from 1 p.m. to 1:59 p.m., which is the direct correlation to the surveillance footage of Gospel Gardens and the footage that Officer or Sergeant Dabney identified the defendant being present for. So next, if all of that wasn't enough, we heard testimony from Sergeant Browning. Sergeant Browning said that this defendant's device placed an outgoing call to Anthony Mims at 12:25:40 p.m. on November 17, 2021. Not only did he place an outgoing call to Big Jook, he also received a text from Kiana Hooper, who is his cousin. She texted him an address of 4752 Haven Court. After he received that address, he then sent that address to an associate named Jermaine Sears. Jermaine Sears, or defendant's device, sends the outgoing text to Jermaine Sears that he needs him. And you'll see in the surveillance footage of Haven Court on that day, at that time, a car that is associated with Jermaine Sears arrived shortly after the defendant arrives in a white Ford Expedition. So the next thing, convicted felon in possession of a firearm. The three things that we have to prove beyond a reasonable doubt is that 1, this defendant was a convicted felon or convicted of a specified felony. And 2, after being convicted of a felony, this defendant possessed a firearm. And 3, this defendant acted intentionally, knowingly, or recklessly. So the facts that we have for this charge. Well, 1, there was a stipulation or an agreement. The parties have stipulated that defendant Justin Johnson was convicted of a felony on May 2nd, 2017 in Criminal Court 8 in Shelby County, Tennessee. Next, we heard testimony from Cornelia Smith, who verified that the person in that Bass Pro hat was Justin Johnson, and that person held a gun. So based on all of that, we can see that we have met our burden of proof for convicted felon in possession of a firearm. Next, let's just talk about reasonable doubt for one last second. Reasonable doubt is not 100% certainty. It is not beyond a shadow of a doubt. It is not beyond all doubt. What's required is moral certainty. Certainty that allows you to sleep well at night. Will you be able to rest easy knowing the decision that you made? My instinct says yes. And once you've had time to deliberate, I think yours will too. So that brings us to the end. The state has met its burden of proof beyond a reasonable doubt. You have all the evidence, all of the testimony, all of the stipulations, all the videos, all the photographs. And now it's time for you to consider that evidence and apply your common sense. And after you do that, I expect that you will find this defendant guilty on all charges. Thank you.
Thank you, Ms. Williams.
Thank you, Judge.
It's good to see y'all again. This is the last time you're going to have to hear from me. And as I see all of your faces, I know that's something you're looking forward to. And that's okay. I know that you all want to get back to your lives. And I can tell you on behalf of Mr. Johnson that your attention during this trial is greatly appreciated. What you've had to set aside in order to provide this service, I have no doubt that the court, and Mr. Hagerman, Ms. Iris, all of us agree you're indebted to you for that. Because like I said in opening, this is important. And you're about to have to roll up your sleeves and go to work. And it's going to be a difficult job. This young man's fate is in your hands. The concept of justice, right? We talked about that in Fort Dyer. We talked about that again in opening, right? And it's in your hands. Meting out justice. And it's difficult because what you've heard is the tragedy of someone losing their life, of their family members not having that person in their life. And that is terrible, and the court will tell you, as terrible as that is, you can't consider that when you're determining guilt or innocence in this case. But it's heavy. And on the other hand, you have Mr. Johnson. This young man that you heard in the evidence is a young man, aspiring rapper, wanted to make it as a rap artist. When you're going back through these exhibits, you're going to see a picture of him in front of the house on Bradley, engaged in a music video, right, for his rap.
Still in the building with me, man. Hit that like button, hit that subscribe button. We out here in the building right now, man. Turn us up.
Because that's what he wanted to do. And his fate is directly in your hands. And like we talked about, it's never justice to wrongfully convict someone. And so that determination that you're going to make beyond a reasonable doubt is the heaviest one, maybe one of the heaviest decisions you'll ever make. And you've had an opportunity to sit through the trial and hear the evidence, observe the witnesses, and you've been told, keep an open mind. And I hope you have. I'm sure you have. And not to talk about the case. The thing that you've been listening to for days with people all around you that have going through the same thing, and then you have to be around them even when you're not here, and you can't talk about the elephant in the room. But today that changes. And not only are you allowed to talk about it, the judge has instructed you that you have to talk about it. And to engage in deliberations meaningfully. To listen to one another, to review the evidence that you've heard, to talk about it, and render a decision. But to the degree you're working together, what you never have to do is abandon.
We finna sit here all day. They got all day. They gonna come with a decision today, buddy.
Now, I don't mean conscience like Cornelius Smith had conscience. Because I don't think he really meant that when you heard from him. He said, the reason I decided to tell the truth is I got a conscience. And we all know that's not the type of thing you're dealing with. You take that more seriously. You mean it. He didn't.
You better get on his ass.
You've heard a lot of concepts, the terms of art and the law.
Lawyer, I think that straight drop lawyer, that's the one was like, you got paid $50,000 for your lawyer and you still up here snitching. He better cut in. He better come. He coming in and painting a picture now. He finna go harder. He better go harder, G.O. I want my $50,000 back.
All the burden of proof, presumption of innocence. And when we started this, I told you, Mr. Johnson sits before you innocent. And I'm again telling you today, after the state has closed its proof, he remains that way. He didn't kill Adolph Thornton Jr. He didn't conspire to kill Adolph Thornton Jr. And he wasn't the man holding the pistol in the Guity video. And it's going to be up to you to decide that, to watch those videos. Watch them closely. They want to talk about those videos, and I'm encouraging you to study them. Give them a close look. The state doesn't want to acknowledge what I told you in opening, and that is similar. It doesn't mean the same. Plenty of people have gray sweatpants, black shoes with white soles, black hoodies. And as we learned through the proof, in Memphis especially, and elsewhere, Bass Pro has. You can look at it, if we had a window, you could look at it and you could see the Bass Pro, which is the pyramid here. You also heard testimony about it being a fad at that point in time. Famous rappers wearing it. Other famous artists. I think I mentioned Gwen Stefani wearing Bass Pro. One rapper has a signature Bass Pro hat. You heard from one of the detectives that they even interviewed someone who gave them a potential suspect that wasn't Mr. Johnson and said that person always wore a Bass Pro hat. You have to consider that. And then you have Sergeant Dabney, who, for the first time, and I think he acknowledged this, sitting on the stand, says, I think those underwear are the same. They're both blue. You look at the underwear from Tulane Apartments, you look back at the Guity video, those are the same underwear. Look at it. Look at the steel shots. And for yourself, determine, can you tell if those are the same? And as jurors, you get to make that call. You get to look at it for yourself and compare those. We've heard a lot about it's not 1981 anymore. And I agree. Right? You know, we've got cameras, but like I told you in opening, what also has advanced tremendously since 1981 is the world of forensics. Right? Fingerprints, DNA, touch DNA. And you have to ask yourself, why is Justin Johnson's DNA nowhere in that car?
You're getting at it, but you need to come hard, dude. But you trying to paint a picture, but me being a opposite observer, I'm not seeing the picture that you saying that it ain't Justin Johnson. You need to come with an angle that about the dude testifying and blaming it on Justin Johnson. That's the picture you need to be painting, bro.
There's DNA in that car. You heard a lot about they wiped it. Cornelius Smith said he wiped it. And we'll get to whether you believe that or not in a minute. Okay? But he says he wiped it. But he didn't. There's fingerprints on it. Kristen Garner's, Trayon Ingram's, and Cornelius Smith. There was DNA found. One of one of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. Now, they want you to believe that Mr. Johnson's running around in this Mercedes, and the reason that his prints aren't on it are because he's wearing gloves. And mind you, Cornelius Smith, when he said he wiped the car, never said he wiped the driver's side of the car. Okay? If you believe that. And they want you to believe Mr. Johnson's driving around this white Mercedes, including with his daughter. Look at those videos. You think, he's not wearing gloves. And he's got a little girl in tow that would presumably be in that car with him. No DNA recovered. None. Now, during proof, it was interesting because they would show the Mercedes go into crosstown and the Mercedes leave crosstown, and they would show a video of Mr. Johnson getting out and walking in the building or walking out of the building. There is no video that shows Mr. Johnson in that Mercedes. And you heard they had a reel, right? The video was a reel when they're doing crosstown. And when I asked it, I think it was Detective or Sergeant Dabney, about there was surely other cars going in and out at this very time. And he said, yeah. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told him. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly, he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas, and goes, that's not me in the video. And he's like, okay, it's me. But they're trying to tell you Justin Johnson's at the Valero gas station, right, when he's pumping gas. Where is he? Now, they want you to believe that this shadowy figure up in the right, top corner was Justin Johnson. And that he was the other passenger in the Infinity, but you can't really make out who he is. You have to rely on Kristen Garner. That's what you have to rely on. And we talked a little bit about, proof beyond a reasonable doubt. And I said one of the ways that you could use to kind of understand it is proof so convincing that you would not hesitate to rely upon it in making the most important decisions of your life. And it's really simple, right? You look there and you go, would I trust Kristen Gardner with anything? If he told me something, would I believe it? The answer is no. Because the more he talked, right, the more you realize he and Trayon are in the Mercedes. They're driving around with a Draco rifle, assault rifle. The same one described as being held by Cornelius Smith in the shooting of Adolph Ford Jr. Their prints are in the car. He says they have, well, he said a ton of guns in that car. And then he starts talking about how he's related to Dolph, and they were trying to dump the car before, right? And he's reaching out to Dolph's people to try to get rid of a car, which is the reason why after this happened, immediate day after, he's calling Trayon going, my name's in this. My name's in this. Why would his name be? And B, why couldn't he just say, oh, I have anything to do with this?
When you come in here, hit that like button and hit that subscribe button. Long live Flipper, man. Drop them flippers in the comments.
At Valero, you do see Trayon and Kristen. They're there front and center. Now, there's been a lot of talk about the phone and location. And in the state's argument just now, you heard her saying what the expert said, a phone using, a tower that could be and he said could be. He said was in the service area of the Valero gas station. Or then he said, I didn't do any drive testing, so I can't say what the coverage area would have been. Right? And when you're looking at his slides, you've got that really thick PowerPoint exhibit. You'll be able to look at it. And you notice, right, that you're going to notice that the pictures are all really small. They're really zoomed in on the map. And he's talking about, like, this, do you think this is thorough? This is thorough. I mean, he's going through all these calls. Look at what he's doing. I mean, but then you have to ask yourself, well, what happens if you expand the map? And then you realize, and this is the exhibit I entered, you realize he's not even counting all the data and calls, because when you show what he left out at 12:23, right, at the time immediately after Adolph Thornton Jr. was shot, there are several towers that Mr. Johnson's phone gets off of that are, one's 3 miles away in one direction. The other one is 3.2 miles away down by the Memphis airport. And then he has to go, I left those out. Not a really good explanation for why, right? Important. When there are a group of fine people that are looking to find the truth and have to make this decision and need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for. But also, I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this.
Giving me my money for
There was no evidence at all that Justin Johnson was present for any meetings discussing this hit.
give me my money's worth, dude.
What Cornelius Smith said was he met with Hernandez Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you,
What? Bang, bang, bang.
The more love we give, the more grand.
this little girl leaving Crosstown that morning. It's just thorough. I mean, he's going through all these calls. Now, during proof, it was interesting because they would show the Mercedes go into Crosstown. One of it coming back to Trayon Ingram, right? Not Justin Johnson. Now, there's a lot of talk about gloves, right? They made a big point to say, you see gloves in the video. But you have to ask yourself, was Justin Johnson ever in that Mercedes? So let's go to Kristen Garner. Kristen Garner gets up here and tries to tell you that. He tries to say he didn't know the car was stolen, that Trayon was driving around in the car. And at first, he acts like, even under questioning from Mr. Hagerman, that he wasn't even present when the car was exchanged, because he tries to say, well, Trayon told him. And if you recall, Mr. Hagerman had to kind of go back at him. I think he said something like, I can't tell you that. And then he eventually started answering some questions. You also remember that this is the same guy that went into law enforcement and said, I've never been in that car. I don't know a guy named Justin Johnson other than on Instagram. He's a rapper. And then suddenly he starts evolving through the story. Still lying to law enforcement. He even looks at a video of himself, right, pumping gas and goes, "That's not me in the video." And he's like, "Okay, it's me." But they're trying to tell you Justin Johnson's at the Valero gas station, right? When he says this. And need to evaluate the accuracy of what he's telling you. And then you realize that when you talk about coverage areas and where things are in relation to these phones, somebody could be anywhere in a 3-mile radius, either any direction. And then you have to go, what is it? What does it show us? How did that help? How does that make you any more certain of someone's presumed location at a given point in time? Because he said it's not an exact science, and I'm not here to tell you that I can pinpoint where he is. And I didn't do drive testing, and I don't know. The next available tower is what a cell phone normally would look for, but also I can't even tell you if the towers were down at the time. That could make a difference. That could put you further out. I couldn't tell you if they were down for maintenance, if they were overburdened. And he said, look, if the tower's real busy, it'll direct you to the next tower. But what it doesn't establish is that Justin Johnson was involved in the conspiracy to kill Adolph Thornton. It doesn't establish that he killed Adolph Thornton or possessed a firearm. Now, a little bit about conspiracy and some more of the facts as you heard them from some of the other witnesses. Now, I have to take a little bit of an issue with the state on something that was said during their initial argument. And that is this. There was no evidence at all that Justin Johnson was present
still right here
for any meetings discussing this hit. What Cornelius Smith said was he met with Hernandez-Govan and Jook, and Justin Johnson was not there. And then he said he met with Hernandez-Govan and others on another occasion to discuss it, and Justin Johnson was not there. So to suggest that he was present and agreed, where's the agreement? He wasn't there. Now, you get to Mr. Smith. The court has already instructed you about accomplice testimony and is already warning you that when you're considering that, you have to use caution. Now, you also have to apply the credibility factors that are in the jury instructions, but they're not an exhaustive list, right? Like we talked about in voir dire. Some of you, most of you.
Just keep stopping.
We'll find out who did this. Information that made him where the state had on it 11:51 in the morning. And then, of course, Mr. Hagerman came in, acknowledged the mistake to say that wasn't the right time. and put an officer on the stand, the lieutenant, to talk about getting access to the time, how he got the timestamp. But what that shows you is this. They don't know what time it was that day on that video. They don't know. I mean, mistakes get made. I'm not here to suggest that they don't. But you have to ask yourself, okay, the mistake got made, and then there's a timestamp. Okay, we want to put the timestamp one in. That seems like the logical choice. But then you have to listen to the lieutenant, right? And go, Lieutenant, what did you do to check and confirm that these were accurate times? Well, I looked at the live feed when I was in there. I had to have a technician. It's a computer. I don't understand it. But when I was there, I looked up at the screen and it appeared to be the right date and time. But not one person, you didn't hear from anybody that could say, that was confirmed, that's accurate, nothing happened with the system beforehand. And you even heard him say, it is not uncommon at all to pull surveillance cameras that have inaccurate date and times. Because you have to ask yourself about timing. You have to ask yourself about timing of leaving Crosstown, Mr. Johnson presumably going all the way to Whitehaven, if he's in that Mercedes and dropping his daughter off, right? And he said 20 minutes, something like that. Then he's supposedly driving all the way back to Wild Rose, 20 minutes, thereabouts, to pick up Cornelia Smith. They got to leave, then turn around and go to Bradley and go back to the white truck, right? And then get out and be in front of the Makita Cookie at 12:21. Now, that part of common sense and your everyday experiences, what does that tell you about going one place to the other? Right? Takes longer, right? If you're stopping places, if you got to park, you're presumably dropping a child off, there's going to be some kind of a exchange of a child, maybe a discussion with a person, and you build all that in. That's a lot of time. And I would submit to you that one of the reasons that became an issue is about correcting that time is when the state realized that I was asking questions of that witness and asking him how long it would take to get from point A to point B to here to here to here. Because when you do the math and it's 11:51, it doesn't work. It doesn't work. And all this about Bradley, even the exchange of the Mercedes for the Infiniti, the dropping of the Mercedes at Bradley and picking up the SUV, whether somebody cleaned the Mercedes or didn't, who moved their Mercedes to the backyard, all of that, according to Cornelia Smith, should have been captured on Hernandez Govan's home security system. Right? He said Govan had a security system directly facing Bradley because that's why when he decided that he was going to go wipe the car down, either the day it happened or the day after, he couldn't quite remember, he texted Govan and said he was coming through there because he didn't want Govan to mistake him for somebody trying to come up on him. I asked Detective or Sergeant Dabney Did y'all canvass? Yes, we canvassed the neighborhood. You know, he didn't do it personally, but he would have presumed they would have talked to everybody, including Hernandez Govan. Right? We don't necessarily know if they did or didn't, because we didn't get to hear from Mr. Govan. You know, I asked Detective Browning if he was aware of any video from there. No. But if Cornelius Smith, right, is this person that's telling you the truth, because the truth doesn't change, then the fact that there were videos would have been known as early as March of 22, when he was meeting with law enforcement. And you know, doesn't want to find out who did this. They would have absolutely went and looked. But we don't know. We don't know. And there's a lot that you should know that you don't. Because there's a material witness that should have been called by the state that wasn't called. Hernandez Govan. And maybe some of you sat through this and thought, I want to hear what he has to say. And when I told you in the opening statement, I said, it's important, right? For you to weigh out and be able, as part of your duty as jurors, to be able to compare those two testimonies together. I'm sure some of you were thinking, yeah, that would make sense. I know we talked about that in voir dire, about getting two people to talk to kind of differentiate. You know, some of you that may have been a teacher, talking about that is one of the ways that you try to figure out who's telling the truth, who isn't. But you weren't able to do that. You weren't able to do that. You were deprived of that. And to be clear, as you heard about Hernandez Govan, he was cooperating in this investigation. He met with law enforcement on at least 2 occasions pursuant to a proffer agreement, which meant he was allowed to go in and give information and not have his words used against him later. I don't have the ability to make good on a proffer letter. Only the state does. I don't have the ability to wave a magic wand and give him a reduced sentence if he comes in and testifies for me. So he's to my exclusion. He's to Mr. Johnson's exclusion, and ultimately to your exclusion. And if this is a truth-seeking function, why didn't the state call him? And it is. Your job is to find the truth of the matter. And ultimately to go, did they prove their case or not? But you were deprived of that. And the judge instructed you about a jury instruction. And that's the law. That's part of all the different things she told you. This is as important as any of them. And the law states that it creates an inference that the testimony of that witness, Govan, would have been unfavorable to the state. Now, it's up to you to decide whether or not he was unavailable, a material witness, and whether or not there should be the inference. But you're allowed to make that inference in here. And unfavorable, I would tell you, unfavorable to the state means favorable to Mr. Johnson. And knowing that, Can you really render a verdict of guilty and have your mind rest easy? And not walk away and go, I just don't know if I did the right thing. Knowing that there was information out there that could have been presented to you and wasn't, that would have been favorable to Mr. Johnson, that I couldn't give you. Can you be morally certain in that instance? In order to be convinced beyond a reasonable doubt that Mr. Johnson is the one in that Nikita video, you have to consider everything. You have to consider what you heard. And you have to go, what I heard from Kristen Garner and Cornelius Smith, was that so convincing that I wouldn't hesitate to rely upon it in making those most important decisions in your own life? Will my mind rest easy if I convict this young man based on their word in conjunction with that video and the other videos and what you didn't hear? The answer is no. When you examine your conscience after you've taken the time to deliberate, I think you'll find the answer is no. Two things I want you to remember, and I'm wrapping up. The way the burden of proof works. You've heard this statement, right? They ain't got nothing to prove. You may say that to somebody. I ain't got nothing to prove here. Justin Johnson, he doesn't have anything to prove here.
But he got a lot to motherfucking lose. He got a lot to motherfucking lose, man.
And we've all heard the term benefit of the doubt. Everybody likes to give somebody the benefit of the doubt. You are legally prohibited from giving the state the benefit of the doubt. You can't carry their water for them. Again, I appreciate it. This is, as I said, the last time I get to speak to you. The state's going to get one more opportunity to talk to you this morning. They get the last word. That's how the system's set up. But it has been my honor to represent Mr. Johnson in this case. It's been my honor to present this case before you all. And thank you so much.
Thank you, Mr. Mayor.
Fuck him up.
We started this with a little Memphis talk. Those cookies are
See them
fire. I think that's how we started it.
See them pants he got on, he on bullshit from the jump, gang.
Little more Memphis talk. What y'all even talking about? What y'all even talking about?
He using slang in there.
A missing witness?
What the fuck is you talking about? That's what he means.
Fernandez Gomez?
That's Chicago.
A
What
missing witness? Fernandez Gomez? Absent material witness. And the defense wants to say that is Hernandez Govan. What do we know about Hernandez Govan? He's a defendant in the case.
Damn.
He is charged with murder and conspiracy to murder. Whether it's
Yeah, he coming in
television,
straight on. He on their ass. He chewing their
whether
ass.
it's in
This
black and
thing
white
been coming.
at the bottom of that same instruction,
Jokes and everything on their
a
ass.
defendant has the right not to testify and incriminate himself. He is a defendant. He is not a missing witness. That would be insane. I could willy-nilly just start calling every defendant. And they just have to come in here, testify. That's crazy. It doesn't even work like that on television. It doesn't even work like that in black and white in front of you. That would be insanity, and that wouldn't be a legal system where you had a Fifth Amendment right. That would be an inquisition, is actually what they used to call it, where you didn't have that right not to come in court. So the idea that the defense would call a defendant who's charged with this crime an absent witness shows you how desperate it is. And then we'll talk about things in isolation. Look at Kirsten Gardner. I'm sure he knew that car was stolen. I'm sure he did too. Well, then how can you believe him? Or look at Cornelius Smith. I'm sure it's not his conscience that made him talk. I'm sure it's not either. He talked because he's caught. So don't believe him. So I made a mistake on one slide about the time, so it was corrected. So we can't believe video. You know, there's a word that actually exists because it's a thing. It's corroboration. It's corroboration is what they call it. Like, can you look at something somebody's saying and compare it to something else and then determine whether or not that person's telling the truth about it? Because that's how we should judge stuff. Did Kirsten Gardner know the car was stolen? I bet he did. Does he think Treon Ingram actually paid for it because of something? No, we didn't pay for the car. They're riding around with guns in a stolen car, and they're trading it with their buddy, Mr. Johnson. But how do we know that? Corroboration. Is there evidence that shows us that? Well, there's the Valero video, which shows something strange. Shows something strange. Shows Kirsten come up in the car and then somebody else get in and drive off. Strange. Another little piece of corroboration. Where's Justin Johnson's phone at the time? Well, in the area of the Valero station. Can you say it's in the parking lot? No, you can't. But it's in the Valero, in the vicinity of the Valero station. Oh my God, is there something else? Yeah. And this is what is ignored throughout the entire talk we just heard. We don't just have towers. We just don't have cell phone towers. We don't just have a Valero video. We just don't have a Havenport video. We don't just have a crosstown video. We don't just have a defendant who's like, Cornelius Smith, I'm guilty and so is he. That's us two in the parking lot shooting him. We got Justin Johnson's actual phone. We got his actual phone. In this case, it's been over so many times. Things that happen that are actually really dramatic just sort of happen. Because as soon as we saw the video of the Makeda shooting, and as soon as you see the video of Crosstown of him leaving in the exact same outfit in the white Mercedes, case is over. But we keep going. As soon as you hear from a co-defendant who's like, that's me in the parking lot shooting Dolph, I'm going to prison. and Justin Johnson's the guy next to me doing it, case is over. As soon as you see the Haven Court video, 40 minutes after the shooting of the two shooters and his cousin, case is over. But then things kept on happening. That if you didn't have all that proof, it would have even been more dramatic, or would have been dramatic. When they happened, I would see in your eyes a little thing, a little twinkle. We have his phone. And the night before, we have a text. The night before the homicide, we had a text. From who? Treon Ingram. To who? Justin Johnson. Sending him what? A picture of the white Mercedes. What do we have next? Another text. Justin Johnson. Treon Ingram. Dropping his location. Bradley. Kissed and said. They met on Bradley. Then they drove to Valero. And they switched cars. That's corroboration. So do you have to be able to trust Kissing Gardner with the keys to your car? Of course not. You think I trust Kissing Gardner with the keys to my car? But do I know he's telling the truth about this? Well, yeah, I do. Because it's on video at Valero. It's documented in his phone with literal pictures and locations. This is plain and clear. Do I have to believe that Cornelius Smith is talking because of pangs of conscience? No. No. He's talking because he got caught. Is he hoping that the truth will help him? Absolutely. He's hoping that the truth will help him. Is he going to prison after this? Absolutely. He's going to prison after this. Is there anything about his testimony, like Kissing Gardner's, that we can corroborate? Oh my goodness. What's the first thing he tells us about that day? Justin Johnson calls me. I think I missed a call, and then I get a second one. And what do we got? Justin Johnson's phone. You can delete your call logs, which he did from that day, but they're still in the phone. And what do you know? 2 calls to Cornelius Smith from him right before he comes and picks him up at Lamar Stones. That's corroboration. What does Smith tell us? We go to Bradley directly after the shooting, but dump the cars. Dump the cars is important. Because here's another little, real tricky truth test. Justin's driving the white Mercedes. See it in the video, of course, where he testifies to it. He says, we drive to Bradley. He hands me the keys to the Expedition. I jump out of the car. I get in the Expedition driving while Justin parks the car in the driveway there on the front. Well, we know the white Expedition is also Justin's car. We're sending it across town for testimony. What do we see at Haven Court? Cornelius says, from there we end up going to Justin's cousin's apartment. It used to be called 2 Lanes, Gospel Gardens, the address on Haven Court. We see the white Expedition arrive. And who's driving? The white Expedition. Justin's car. Who's driving? The dude with the messed up shoulder and the messed up shirt. Cornelius Smith. I mean, how do you make that up? How do you make that up? They pull up at Haven Court with Cornelius Smith driving and Justin in the passenger seat, just like it had to happen, just like Cornelius Smith told you when he testified. We do the shooting. Justin's driving the white Mercedes. He hands me the keys to the Expedition. We get to Bradley. I jump out. I get in the driver's seat of the Expedition. Justin parks the Mercedes, jumps in, Haven Court. And what do you know? That's what we see. And what do you know? If you're lying, that detail is almost impossible to account for. Corroboration. We plainly see in the video, Haven Court. We plainly see them go inside. We plainly see Justin Johnson come out, meet this character in the Dodge Challenger, get some other clothes, get some bags, go in. We plainly see the Chevy Trax car, Angela Arnold, pick up Cornelius. We plainly see Justin get in his car, the Expedition, and the two pull out. His testimony is corroborated over and over and over. And that's so incredibly important as we do trials. That's how we make decisions. Corroboration. That's why we have evidence. That's why we don't just call one witness and say it's over with. We put evidence in front of you. And one of those moments when this trial was just over again for the 5th time was when we were showing the slide from his phone, from Justin's phone. Cornelius says right after the shooting, Justin calls and FaceTimes with somebody. He says it's Big Joke. The guy that put the money down for this. Number 2 is CMG. Guy that put hits on the other artists too. Cornelius says it's a FaceTime. Spelling out Dolph with your hands. And what do we find in Justin's phone? I mean, delete the stuff all day long. He did. Whole day. November 17th. Delete it all day long, but it's still in there. A call and FaceTime interaction with him. Justin Johnson with Big Joke. Who Big Joke? Cornelius tells you. And there you see it in black and white. It's not 1981. That's true. Caught on camera and everything else, but you're also walking around your pocket with a phone that you can delete a call on, but it's still there. The times you called Cornelius Smith that morning, still there. The time when you called and then FaceTime with Big Joke right after the murder of Dolph, still there. The videos from Haven Court that show you arriving, still there. The videos of Haven Court that see you changing clothes. Did he have enough time to do it? He didn't have enough time to do it. He left crossing at 10:51. He had over an hour and a half to go drop off his kid 20 minutes away and drive 10 minutes. Total trip probably take you 30 or 40 minutes. Yeah, you have enough time to do it. We saw him do it. Memphis Talk, all the times. All the times. Before the murder, we see him at Crosstown in the murder outfit. Similar clothing? No. Identical clothing. Patch on the legs, Bass Pro hat, everything. Before the murder, the Mercedes. Similar Mercedes? No. Back end damage, just like we saw in the video. During the murder, again, caught on video, white Mercedes, back end damage, the exact same clothing across town. Looks like him. Right-handed like him. Gloved up, like Cornelius said. Driving away from the murder. Who you calling? Who you texting? Big Joke. Caught before. Caught during. and then caught after at Haven Court. Video of them arriving and leaving. Caught before, during, and after. That's called being caught all the times. All the times. He is literally caught before, during, and after. Caught all the times. And then what does he do? Then what do we know? Another Memphis phrase. Get on down. Get on down. Across town, the last video. Packing my suitcases to head out of town. Packing my suitcases to head out of town and get on down. Like the police tell us, a man, not just in Memphis, well beyond Memphis. As Jamarcus tells us, he's going in and out of town. As Jamarcus tells us, he sees pictures on social media, Rolls Royce, stacks of money. Get out of town, get on down. The crime has been committed, Dolph has been killed, and we literally see him at the elevator with his suitcases getting on down. Flight can create an inference of guilt. Well, yeah. This case was over when you saw the videos. This case was over when you heard from the co-defendant. This case was over when you saw him at Crosstown with the suitcases leaving, knowing that the manhunt was coming and he was out of town and leaving. Brilliant. Brilliant. Now it's time for us, though. Now it's time for us to get on down, but we don't get on down by fleeing. We don't get on down by hiding.
All right, ladies and gentlemen, I got a few more pages of the charge to read to you. I'm going to pick up on page 29.
Athlete or what if better?
If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be: we, the jury, found the defendant guilty of facilitation to wit, conspiracy to commit first-degree murder as charged and included in count 1 of the indictment. If upon all the proof you have a reasonable doubt of the defendant's guilt of the offenses charged and included in the first count of the indictment under the law defined and explained to you, it is your duty to acquit him. Your verdict will be: we, the jury, found the defendant not guilty as to count 1. You will write your verdict on the outside of the jacket and sign one of your names to the verdict as foreperson. Count 2. The charged offense in the second count of the indictment is first-degree murder. The lesser included offenses in order of consideration from greatest to least are second-degree murder, facilitation to wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. You will next inquire whether the defendant is guilty of first-degree murder as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we the jury found the defendant guilty of first-degree murder as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, second-degree murder, as charged in the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we the jury found the defendant guilty of second-degree murder as charged and included in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next lesser included offense, facilitation to wit, first-degree murder, as charged and included in count 2 of the indictment. If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdicts will be, we the jury found the defendant guilty of facilitation to wit, first-degree murder, as charged in count 2 of the indictment. If you unanimously find the defendant not guilty of this offense, you will next inquire whether the defendant is guilty of the next crimes charged and plead. The first count of the indictment charges the offense of conspiracy to commit the
We've got about 50 million followers.
If you find beyond a reasonable doubt that the defendant is guilty of this offense, your verdict will be, we the jury find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment. Crimes charged and plead. When you have reached a verdict on a particular count, the foreperson will write your verdict as to each count on the outside of the jacket and sign his or her name to the verdict as foreperson. Take the case, consider all the facts and circumstances fairly and impartially, and return to the court with verdicts that truth dictate and justice demand. All right, as I told you before, this is the official copy. Please refer to it. There's just been a couple of minor changes made, but nothing substantial, nothing substantive. Let's put it that way. A few typos I ran into, but other than that, please use yours, make notes on yours, refer to yours. But this is the official copy if there's any discrepancy. The jacket, please. You will have all of the exhibits. We'll go back with you. Please look them over. If at some point you want to watch videos, please let us know. Do you have did you make the list? Okay, is it?
It's been numbered as an exhibit, Your Honor.
Okay, so it's with the exhibits. Do you have a clean laptop? So they can you get us a clean laptop so they can watch videos as they want to watch
Go get it,
videos?
Your Honor.
Thank you. So you will be provided a laptop that's clean, so you can watch videos how you want to watch videos. And there will be a list accompanying the video to show you, to tell you, describe to you which video is which. That makes sense? Okay. So, is everybody in good shape to deliberate? You didn't ready to choose alternates. Everybody good to deliberate? I'm going to call three numbers. Once all three are called, the deputy will escort you back to the back to get your belongings. And then if the three of you could come back out here, because I have a few remarks for you. And then the rest of the jurors, the 12 of you that will be seated to deliberate, will go back and begin your deliberations. Okay? Juror number 18. Juror number 13. Juror number 12. You guys can look at these if you'd like. You can review these.
Oh, yes,
sir. I said.
Oh, no.
Just always. You agree. Just make it a point to let you show me.
Yes, Your Honor. Thank you.
Lunch should be here in a little while. Let me admonish you now. All 12 of you will deliberate at the same time. There should never be an opportunity where 2 or 3 over there eating and the rest of you are deliberating. If you decide you're gonna eat, everybody eat. If you decide you're gonna take a break, everybody take a break. When it's time to deliberate, everybody deliberate. Just let the deputy know that you're doing something different besides deliberating. Okay?
She act like she know it ain't gonna take long for the deliberate.
Judge, you are excused. Court stands in recess.
Court stands in recess.
Yeah, the court in recess right now, so we finna stand by because I don't think it's gonna take them that long to deliberate on this case. It shouldn't take them that long. Real talk, cause it's kind of straightforward. Y'all put down in the chat what y'all think. Like from what we've been hearing already, what y'all think? What y'all think about the case? Like, do y'all think they got enough evidence, or do you think Cornelius' testimony could have helped out straight drop? Let me know what y'all think in the comments. Cause I kind of feel like, it only take one person to not say you guilty. So he got a chance, man. But I don't know, like, we gotta see, like, but to me, from what I'm seeing, that definitely was him with them. That definitely was him at the complex. That's definitely was him going to with his daughter and stuff. That was him with them shoes on. So that definitely was him. So to me, but from what I'm seeing, you know what I'm saying? Y'all hit the like button, hit that subscribe button. This ghetto DVD, man. Look out for the Dolph documentary. I'm gonna start playing some uncut footage. But course in recess right now. And we can have open discussion and we could talk about this case real quick while we got the chance. Yeah, he helped. I think he helped with just he helped because he blaming everybody else, you know, but we could see what he did. You feel me? So like I just feel like his lawyer did all right, but his lawyer should have been a little bit more aggressive with but I don't know, like the state man said it's like an open cut shut case though. So we'll see. We got a little time. It might be 30 minutes. You know, we could definitely see the difference in like you gotta have tactics. Like I just feel like dude snitching, he knew he was going down, so like they said, he was trying to snitch. But I kind of feel like that helped him because Govan snitch and Cornelia snitch. So that and Justin Johnson was quiet, so they could be putting it on him. But he do have a what's the name? He on camera with the car, and he on camera with that other white car, that truck they had. He on camera with that truck they had. So man, we finna see in a minute, man. I don't think they gonna bullshit us until tomorrow. They might do just to get some more views and shit. If they on that. But Memphis, they gonna get straight to the point. I don't think they on that, trying to get some views. I don't really think they on that. Let's see. Yeah, I think they gonna come back. They finna make lunch and shit and come back. No, they're still but they gonna make lunch and shit. They gonna probably make lunch and shit and come back. We gonna stay on point. We gonna stay right here. We gonna be on point. Take me a quick recess like this court. It's gonna take it's gonna take we here, okay, I'm here too. Look, we finna take a quick short recess real quick like this court. I'm finna grab me something to eat real quick. But I'm right here and I'm on as soon as they pop back in court, I'm gonna pop right back online. I got it right here. But yeah though, we here, we gotta see what they on, bro. With my nigga Dolph, I ain't lying, bro, I'm tired. They ain't wanna give us our flowers.
Not everyone's life runs in straight lines. At Sophia, we get that.
They still got country cook things coming through. Yo, what's up? We out here trying to see what's going on. What's good, bro? Yeah, I'm trying to get this shit back up and running, man. Yeah, I should be in the algorithm, especially with young Dolph. And who else would know the most about Dolph? Me. I'm gonna drop some shit too. I got some shit I'm gonna drop. I got some content. Y'all gonna see that shit all over the net. Watch. Y'all gonna see that shit all over the net, man. I'm trying to get this shit back up. Yeah, back at it, man. I got it back running, you know how we do. You know, you know how I go, man. P Flipper, we doing this. We came together for Dolph, man. You know what I'm saying? I ain't never stopped doing it, So, no, I just had a little mishaps. The channel got took and you know, I'm back down, back active. My channel back busting. I'm trying to get my views up. My views ain't too great, but other than that, right here, I'm still here, man. Definitely still here. Still got that same good motivation, still unity, still love, still got the community, you know, still for Dolph, do everything Dolph, you feel me? You still Dolph, man. You feel me? Ain't nothing changed but the date, you feel me? Ain't nothing changed but the date, you feel me? A new channel, the same content. It's just a new channel, the same content. Maybe all my people ain't found me yet, you feel me? But they finna find me now. And I'm finna drop this shit out. They finna find me now, you hear me? Yeah, all my fans probably haven't found and ran across my channel yet. But like people be into Dolph, so they should run across me, you feel me? I got a whole new fan base now. You feel me? So my old fans,
they gonna run across the station and they gonna come back. You feel me? We gonna get my life back busting like how I used to be. We gonna tell a whole story and I know half-ass story. Straight up. Yeah, we ain't doing no half-ass stories over here. We gonna give you the real deal Holyfield. Matter of fact, let me see if I got some real deal Holyfield for y'all. What I'm looking for. But I got another real deal. You know, watch some real deal Holyfield. This I know. This got a lot of shit. It's all messy shit. The other I'm on this shit because, you know, but other than that, like, he ain't just do that, bro. He help niggas for real, like. Dude, about. So y'all, I mean, it's real shit, man. Alright. Yeah, what am I saying? Big Backwood. Big Backwood. I don't usually do this, man. I'm old school. But they done brought me out of retirement. To the name of Dolph. Y'all love the king. The king of Memphis. My boy. So we down here, man, just chilling, man, you know. You know what I'm saying? It's a normal day, but it ain't a normal day. There'll never be another normal day in my life. Everybody else probably going on with their life. I'm stuck. It's like, have you ever been in love and the girl left you and broke your heart? You just stuck. Stuck. I'm heartbroken. But I'm doing it in the name of Dolph, though. Everything did in the name of Dolph. Everything did in the name of Dolph. Big back rule, too. I fucked it up. Oh, the shit more like a fluke. Yeah, I heard Dolph land, man. That's what I do, man. You know what I'm saying?
Big chill to smoke weed, man, to be on the blade. Hey, Stacey. How you doing? Sweaty, sexy bitches, Ain't nothing changed but a little gram around. Is it? Ain't nothing changed. I'm still the same. We hit the studio. Yeah. We hit the studio tonight, man. My artist and shit, man. He got some little shit he wanna do. Like I said, every time we do, we step in the name of Dolph. So he called me up today and told me that he got something he wanna drop, man, in the name of Dolph. You know what I'm saying? So we pulled up in the Squeaky studio tonight. We fuck with them folks, you know what I'm saying? Fuck with them folks tonight up in the Squeaky studio. Let them folks know what's going on. See, I'm glad you got in touch with me. Cause see, I ain't no rapper. I'm the guy that was just down here, in the slum, that nobody cares about, The dog cared about me, Dog made sure I was straight. I'm not a rapper or nothing like that. Gotta watch my back. Yeah. But I'm not a rapper or nothing like that. So nobody will call my phone and try to ask me what he meant to me and what. So this means a lot for me to let the world know. Man, that mean a lot to everybody, not just celebrities, not just the people he gave out turkeys. I got a couple of turkeys that she gave to my mom and shit, because But other than that, like, he ain't just do that, bro. He helped niggas for real, like, for real. And the game that he gave me, I can take that forever. Like, they might took him from me, but they can't take the game that he gave away. They can't take the game that he gave me away. You feel what I'm saying? That's why I say, man, everything I do, I'm doing it in the name of Dolph. Like, you know what I'm saying? Like, everything, doing it in his name, cool. I'm gonna continue to get money. I'm gonna continue to go hard on business. I'm gonna continue to do my thing. When a nigga play with me, nigga know what I'm talking about. You feel what I'm saying?
Hit that like button.
Though. But yeah. I want up but anyway. Yeah, but we'll be at the studio tonight, man. I know that young nigga probably got something hot. You know what I'm saying? And I was really, man, was trying to talk to Dolph about collaborating with him on a distribution deal for my FLE, my record label shit. I'm trying to file a branch out for paper round. That's what I wanted it to be, and that's what it's still gonna be. You know what I'm saying? You hating ass niggas ain't stop shit. You know what I'm saying? Nigga gonna still go on, cause paper round live on. We all bosses. You know what I'm saying? You gotta kill all of us. I was thought I was gonna kill Dolph, everything else gonna die. When they say you kill the head, we all heads though. We like a motherfucking Medusa. Like, have you ever seen Medusa snake head? We all heads, nigga. Fuck wrong with you? Medusa had plenty of snakes on. She had plenty of snake heads on that motherfucker. Playrock got plenty of heads. We ain't snakes, but we can get grab and slime, and nigga, we ain't nice either. Bitch ass nigga, I hate you bitch ass nigga, bro. That's to all you whole ass niggas. But I ain't with no violence though. I ain't with no violence. It's just dealt to all you whole ass niggas. I ain't with no violence though. Sometimes I get a little excited, because I think these niggas think they tough. I want some aggressive ass shit, want to be some bullets. I got bullets. I like bullets. I got a bullet for every bullet. Now, I don't got it. I'm just saying, like, nigga, it's bullets for every bullet, nigga. Them niggas hoes, man. Y'all niggas some hoes. Y'all some real life hoes, bro. You in jail, you a bitch in jail. You getting stored in jail, you a hoe. You a real live hoe, you ain't gonna do nothing. You know what I'm saying? A nigga fight you, bro. Like you a bitch. Like certain niggas don't even be deserved
He talking about Yo Gotti.
to be get shot or nigga just slap you, bro. Just fight you. You know what I'm saying? Cause you a real hoe. You a big bitch. You know what I'm saying? You a big pussy. You feel what I'm saying? You niggas hide. Niggas ain't gonna come outside. You niggas talking about y'all doing shows in Memphis. Where y'all doing shows in Memphis? I ain't saying no nigga gonna do nothing though. I'm just saying I ain't see you do no show. And y'all call it turn the nigga. Y'all call it fucking with a nigga. Saying this and saying that about this and that. Y'all gonna get what y'all asking for. I will tell you. Y'all gonna get what y'all asking for. Y'all gonna get what y'all asking for. Y'all gonna get it. Y'all gonna get it, man. But yeah, you know. Little cuz smoke weed. Nah, look cuz, man. Look cuz, that's my assassin, man. He don't smoke no weed, do no drinking, do no drug, period. He stay on alert. No camera, none of it. He stay always on alert. You feel me? Like, you know what I'm saying? This, yeah. I don't want no problem, but he do. You feel me? So, yeah, the cool don't smoke no weed, man. So when I'm riding in this city, you know what I'm saying? I'm fully on these intoxicated on that weed, and he fully aware, like he just said, watch your back or what? I got your back. Like nigga, don't play. Yeah, nigga, don't forget what's going on. Nigga. Yeah. You know what I'm saying? Like, I ain't gotta worry about this shit. And I know what he gonna do. I know what he gonna do. And I done seen him in action. I know what he gonna do. And I ain't just talking. And nigga know me, know what's going on. Y'all know what's going on. Y'all know. You know what I'm saying? She just killed me, man. Just every day, man. I just wanna go to a Gotti concert. I ain't lying. I just wanna go to a Gotti concert. I don't do nothing. I just wanna go to a Gotti concert in Memphis. No, support my fellow Memphis rappers. You know? Gotti them straight. I'm gonna go to a show. So I'm gonna start following them and see when, you know, next time we go to the show, get my girl. Cause my girl like them too. You know? Yeah. Yeah, I'm gonna do that. You still be bumping Gotti on the cuz. You like that. Yeah. Fuck with Gotti. Yo, Gotti! Go out and get us something to eat. We'll go get us something to eat later on. We'll go get us something to eat, man. Yeah, long live Dolph, man. Long live the king.
This gonna be a dope ass thing, bro.
Man, y'all better come correct, bro. Where you shot made. This Dolph homie too. Where we at right now, man? Right here, where it goes down there, bro. Like, this was all the motherfucking guns behind it was always shit go down there, right here on the corner. Where it's fucking 40 miles across the track right now. Got me scared as fuck. Y'all know I'm dirty as hell. The fucking shit was dying right here. What's going on? This is one of the first spots when Dolph shot his video, one of his videos, you know what I'm saying? Way back in the gap. We had a little bitty thin, draw on Mustang. Got it right all the old people before me and dog put it down there right here. All the old people who gave us paid their way for me and dog come from right here. Right here on this block. So I know when he started, he was right here on the block. He always came right back to this block. This where it is right here. Can't say. Right on Can't say. Real. Shout out to all the OGs, man, who put it down for the hood, man. You know what I'm saying? The ones that ain't got time, you know what I'm saying? They're the ones that don't, you know, they got to stay out the way. I understand what's going on, man. I love y'all, man, who put it down for the hood, man. Paying the way for us, man. You know what I'm saying? We're going to keep this dating shit going. We're going to keep paper route going. We're going to keep that stay going. We're going to keep all this shit going. You know what I'm saying? But tell me now, niggas know what's going on. Just like I got got Castay on me too. Every nigga from Castay got this on. If you ain't got this on, you ain't from Castay. This official right here. Every nigga got to have this on them somewhere. On their stomach, on their back, on their necks. Well, I don't get no fuck on their hand. They got to have Castay right here. Everybody got to have Castay on them somewhere. It don't matter where it's at, as long as you gotta be sad, you gotta be brave, you gotta let a nigga know what it is, what it is, you adapt this shit, you live this shit, you breathe this shit. Can't say it is what it is, bro. You know what I'm saying? AKA Dolph land, bro. Rip say, L nigga gotta have that on. Alright, he was like, L nigga gotta have that on. Here go white folks. This is when I first met white folks. This got crazy. Got the whole Suzuki get up. All white. Yeah. If y'all want something to play with, shit your hand and squeeze it, bitch. What's going on, gangster? I guess I see. I stack it. What? Who's going through that, man? Wreck my shit, tore it up.
Man, you bitches. Like, yeah. Don't put that on camera. Go work your shit. Get fired out. What? Right, yeah, it was right fuck. Trying to wait them to get back on court, man. Let y'all know this shit real over here. This shit ain't no play, boy. Waiting on this court to come back in. Let me take a minor short recess. I'm finna take a quick recess.
We still here waiting on deliberations. I need my thing. I'm finna charge that phone up. We out here trying to make something happen. You say all my content ain't real content. Absolutely right. Still waiting. Yeah, I'm covering it. We finna take care. I'm covering Larry Hoover case when it come out. That's it. What's today? Today is the 26th. Let's see what's Larry Hoover case. He was on it say Gangster Disciple founder. I'm finna tell you what's up with that right now. It says I think this the article. Let me share it with y'all. Hopefully this thing don't keep on. I always gotta sign into some shit. Team. Say Gangster Disciple founder Larry Hoover. Come on, I just signed in, dude. And a long shot to be wait. See, they trying to. Let me find this article somewhere else. They playing with me. We finna find it. The article right here. They won't let me use it. They want a motherfucker pay $1 to read the damn newspaper. That's crazy. I'm trying to see what's up with this Larry right now because he supposed to been in court. Court over with. I'm looking for this Larry right now. We waiting on this verdict. Let me do this one thing I came in here really to do real quick, and then I'm gonna get back to finding that Larry. Man, they finna come with that verdict today, gang, because it's early. I doubt if they be waiting, gang. But I can say it's a few, straight drop might got a few loopholes, man. He got everybody watching. Everybody updating their shit too. He gonna seal his fate today. He might be going home, you heard me? He might be going home. If he get out of that shit. If they let him go, they want something to happen to that man. The only article they got, I had to go all the way to the store for a fucking newspaper. Let me see if I can get this shit on my phone. They might put in a little overtime on his ass. Y'all hear me? He might put some overtime in on that ass. finna see if I can find this article for us on this Larry. So y'all sit tight. I don't think they gonna let him go through grow though. But if he do, it's gonna be hell in Memphis. They might tear that bitch up. Man, but you know what? What getting straight drop off is dude snitching. I'm telling you. When a person is snitching, they could throw that onto another person. Yeah, they still stepping for Dolph out there. We waiting on these motherfuckers. We want to hear this verdict live. We waiting. I'm finna see if I can find this Larry article.
All right, I got the Larry Hoover article. Got it. It just came out too, 3 minutes ago. Here it go, right here. Hold on. 2 days. Let's see. Here it go. No, this ain't it. Hold on. Here it go, right here. All right, we found it. See how I be on business for y'all? See how I be on business for y'all? See how much I love y'all? Still waiting on the verdict. All right, we finna share. We'll be sharing this. All right. All right, kid. Judge challenges gang kingpin Larry Hoover mercy bid. How many murders did he cause? U.S. District Judge John Blakely did not rule during Thursday roughly 90-minute hearing in which the gangster disciple co-founder Larry Hoover, co-founder, made his first public appearance in years. A federal judge considering, I hope I ain't gotta log into this shit to get there. I might have to, but they don't do that. I'm gonna look on him. I can really. Okay, it said watch a 30-second video. Hold on, I'm gonna come back after I watch this video. This ain't even fucking thing. Yeah.
All right. No, thank you. I just want to watch the article. All right. A federal judge considering a possible sentence break for gangster disciple co-founder Larry Hoover challenged Larry Hoover defense attorneys Thursday to answer a key question. How many murders do you think he's responsible for? Like, damn, like, who is actually counting? So, I wish I could close that. U.S. District Judge John Blakely asked a question during a hearing over Hoover's push to be resentencing under the First Step Act, a 2018 law signed by President Donald Trump that made certain sentencing reform retroactive. However, attorney Jennifer Bojin said she wasn't prepared to answer Thursday, but would like to reflect. I would like to answer that question, Beijing said. Blakely, who handed down no ruling during the nearly 90-minute hearing, gave until October 7th to do so. So his next court date is October 7th. The back and forth played out with Larry Hoover, 73, making the first public appearance in years at Bet by video. He could be seen on screen wearing a tan outfit and glasses, sitting before what appeared to be a courtroom with his hands shackled. I am a completely different person from the man that entered prison in 1997. However, told the judge, I have had a chance to reflect on my life and the trouble that my existence had caused in the community. If released, I would take the time to try, what's the term, redeem myself for some of the trouble I caused in the community. The late U.S. District Judge Harry Leuenweber gave Hoover a life sentence in 1998, insisting that Hoover had misused his ability to lead thousands, a gift from God. But Hoover lawyers set out in 2019 to undo the sentence under the First Step Act. Some of Hoover's co-defendants have already seen mercy under this law. However, Hoover and Barksdale created the Gangster Disciples by merging two street gangs in the late 1960s that ruled as King Larry and King David until Barksdale was killed in 1974. Meanwhile, Hoover ordered the execution of William Pookie Young, whom, however, I ain't got my glasses on. Whom Hoover suspected stealing from Hoover drug stash houses. Another gang member shot Young in the head 6 times and dumped his body in the alley on February 26, 1973. Hoover was convicted of the murder after a trial in December of 1973, and a judge sentenced him to 150 to 200 years in state prison. That didn't stop Hoover from running the gang through. It also
wait, it is height in its height in the early 1990s. Prosecutors say gangster disciples brought in about 100 million a year in drug sales under Hoover leadership. Hoover was careful not to talk business during the jailhouse phone calls. So in 1993, authorities got a judge permission to monitor conversations by placing transmitters and visitor passes given to the gang leaders who would go see Hoover in prison. Hoover was eventually charged with 40 crimes, including engaging in a continuing criminal enterprise, and found the judge found him guilty of all charges on May 9th, 1997. Since his sentencing by Lewin Weber, his attorney say he should go to court. Hold on. It's
It's a common term, right?
Common term.
We back in business. The Dolph trial on.
I don't know that I can even say
But-
all that to them. I probably can just say no, or
I think you could say no. The only other thing I can think of is you could direct them back to the part of the jury instruction that says, based on your everyday experiences, you know, that one line, I can't remember where that's at, but I think you know what I'm referring to.
Is there a legal definition for the term agreement?
So Larry, go back.
Court's back in session.
So for the record, the jury had a question. Their question is there a legal definition to the term agreement relating to section 1, page 5? Agreement is in quotation marks. So I don't think there is a legal definition to the term agreement.
Don't either. I remember struck it as answering a question before with a jury saying that when a word doesn't have a legal definition, you know, as applied here, go with the common, you know, usage. But beyond that, I don't think anybody can comment on that.
Right. Or I can say, no, there is no legal definition, which leaves them with their common knowledge about the word.
I would just suggest to say common, you know, like you said, there is no legal definition, and when there's not common meaning of the word, but everybody.
Mr. Evans.
I think based on kind of thinking about it for a minute, I think I would suggest just saying there's no legal definition. I don't have a problem with saying.
If that's what Mr. Evans is asking for, that's fine.
With saying something to the term of, you know, everyday usage or What I was referring to is consider all the evidence in light of your own observations and experiences in life.
Larry Hoover gonna be back in court
Specific
October 7th.
defining a term, so that may not be helpful.
They want to do a little bit more research or something. They want to answer how many bodies is he responsible for. I don't know what type of stuff like they own with him, but.
All right, and I'm just gonna respond to this in writing.
So October 7th is next court date.
Okay.
He say, what's going on with old man? They want to know. See here, go right here. See October 7th. Who was handed down a ruling during a nearly 90-minute hearing, gave her until October 7th to do so, to answer her question, how many bodies is he responsible for? He on the way, yeah.
There is not a legal definition for the term agreement. Okay. I think the less the
They
better.
wouldn't even be entertaining it. You right.
Okay. All right. Thank you. Adjourn court.
So what, they going back in? Yeah, they going back in. So, yeah, man, Larry, I guess, let me go get the question, exact question. Hoover attorney Jennifer Bonjean said she wasn't prepared to answer. Okay. U.S. District Judge John Blakely asked a question during a hearing over Hoover's push to be resentencing under the First Step Act, a 2018 law signed by President Donald Trump that made certain sentencing reform retroactive. Wait. Okay, here go the question. A federal judge considering a possible sentencing break for Gangster Disciple co-founder Larry Hoover challenged Larry Hoover defense attorney Thursday, which is today, to answer a key question. How many murders do you think he's responsible for? Hoover's attorney, Jennifer Bonjean, said she wasn't prepared to answer that Thursday, but will likely reflect on it. I would like to answer that question, Bonjean said. Blakely, who handed down no ruling during the nearly 90-minute hearing, gave her until October 7th. So what's that, 2 weeks? That's like 10 days. That's, matter of fact, that's 11 days. That's a week and a half. He gave Larry a week and a half. I hope he ain't responsible for none. Like, he ain't pulled the guns, or they like the new evidence and shit they be using now. Oh, they would have went to Larry's house. They would have went like how they was following straight drop around before the crime and after the crime. Man, with this new technology, they need to use some of that on Larry case. Like, bro, like they supposed to have Larry before he went home, after he went home. Like, if Larry is not pulling the trigger on these niggas, you can't really put no bodies on Larry, to me. Anybody could say that shit happened. Anybody could say, oh yeah. Anybody could say, yeah, anybody, oh, Ghetto DVD, GD, and he killed 5 motherfuckers, it's Larry's fault. Nah, bro. It ain't. That's how they was doing Larry, bro. They doing cause the shit in the projects they putting on them. The shit on 69th they putting on them. All that, this shit is stupid, bro. So hopefully, now we gotta wait another week. We wanted some good news today on Larry. We waiting on straight drop. That's the kids learn this right now. Like we waiting on Larry. We waiting on Butter to see what's going on. We waiting on straight drop case. This is a waiting game. Crime is a waiting game. And I don't have too much time to wait no more. I need this shit now. Crime, you doing crime, that shit is a waiting game, man. You gonna be sitting there waiting for a minute. Who wanna sit and wait for crime? Larry been in jail since 1973. They didn't sentence the man to life until 1996. He already did damn near 25 years. Then, now, the man been in jail 50 years or more, dude. A life sentence to me, it could be life. That mean they won't want you out, but come on, man. Like everybody deserves a second chance. Like 50 years, that's the bare minimum. Like you giving a nigga 100 years and 200 years, a nigga lifespan ain't even that long. We only expected to live to like 70 to 100. Like, damn, y'all giving out sentences longer than a nigga lifespan. Damn. You couldn't you give me something that I could do. Yeah, bro. It says it right here. Larry 73, he got locked up in 73. Look, it says it right here. Meanwhile, Hoover ordered the execution of William Pookie Young, who Hoover suspected stealing from Hoover's drug stash house. Another gang member shot Young in the head 6 times and dumped his body in an alley February 26, 1973. Hoover was convicted of the murder after a trial in December. That was the quickest fucking trial ever. They railroaded him. Even straight drop murder trial was 3 years. I fought an attempt murder for 7. I did 4 in the county and 3 on the streets on bond. Now you tell me back in the day they was moving that fast in court from February 26, 1973, and he was convicted December 1973, and a judge sentenced him to 150 to 200 years. That's some bullshit. Then they got on him and was wiring him and all that shit. That's an invasion of privacy. For real, it is, man. It should be some type of line and some type of barrier where they don't cross the line, man. They don't have no type of boundaries or barrier when they trying to get you railroaded, bro. They railroaded Hoover. I just looked at it, bro. Ain't no way. Ain't no way, bro. Even straight drop murder case. Look how long O-Block them case was. They killed Duck while I was in jail in 2020. O-Block ain't even sentenced yet. It been 4 years with that. It been 3 years. So how did Larry go through court from February 26, 1973 to December 1973? and got 150 to 200 years for a crime he didn't commit. For somebody saying he sent them to do it. That's some bullshit. That's some bull. I ain't sent that nigga to do shit. It's time for Larry. I know silencing and secrecy is the first rule, but damn. Man, I ain't sent that nigga to do nothing. For real. For real. I ain't sent dude to do shit. You hear me? Straight up. And Larry could walk free. Man, I ain't sent dude to do shit, man. We had a crew together. We had a little organization. And they just started putting shit on me. I don't even remember that motherfucker. I don't even remember, dude. If I was Larry, I don't even remember. They put that. When that lady go back, she should be like, the answer is Larry Hoover is not responsible for anybody's. Because he ain't shoot nobody. And he barely knew them motherfuckers. He don't even know them motherfuckers. I go in there just like that. Hell yeah, bro. You talking about it. The 70s. You know them folks ain't have to answer for their actions on back then. You damn right, gang. You damn right, man. They was just getting down on motherfuckers. Yeah. All the way up into the early 2000s, the police been getting down on motherfuckers. All the way up into 2008, G. They was beating my ass. Straight up. The police when them switches came out about 10 years ago, and the high power and these young niggas start getting them all the Glocks and the guns, the choppers and shit. When that shit hit Chicago, that's when the police fell back. Them bitches was ruthless. They want to have the nerve to have mace and shit now. They was beating niggas' ass, popping niggas. They was killing niggas. You tell me you bitches got mace? They just pop Lil B in front of the house for no fucking reason. Yeah, they made some rules up as they went. Y'all, that's how they do on this YouTube shit. They make laws up as they go. All right, who the fuck is you to make up the rules? Who clout chasing? Who doing this? Who the fuck is you? Man, they say straight drop mad, fuck. They say straight drop fucked up, bro. They say straight drop fucked up, gang. Y'all hear me? They say he fucked up. I'm finna show y'all this picture. They say he fucked up, man. He thinking about that shit right now. He straight dropping that bitch right now like, man, why the fuck did I even think about some damn Dolph? On the real, he thinking about that shit. He said, I shouldn't even been thinking about no motherfucking Dolph. For real. When dude went and started blowing, straight drop ain't even had to shoot them little 2 or 3 times he shot. He could have kept them bitches. Hey, straight drop right now, man. They say he fucked up. Man, I bet you he wish he ain't never think of a Dolph. I bet you, hey, M-Town, I bet you, that motherfucker, let me show y'all this picture. Let me get y'all this picture. Hold on. That motherfucker wish he never even thought of fucking Dolph. That motherfucker wish he never even seen the goddamn Dolph. Never heard a Dolph song. Never none of that. He wish he never even thought of no fucking Dolph. That nigga sitting here thinking he wish he never thought of a Dolph. Yeah, he had them pistol, some other shit, some carjacking or some shit. Let me see if I can email this. Man, I bet you that nigga wishing. He like, man, I wish I ain't never even see no fucking Dolph. He like, man, bro, I wish I ain't never even see no Dolph, man. Let me show y'all this picture. He like, man, I wish I ain't never seen no fucking Dolph. Look at this. Straight drop, wish he never seen no fucking Dolph. Hold on. Wait, hold on. What I'm trying to do. Okay. No, I'm looking for. Is it that? No, it should be Gmail. Well, I got two of these open. Yeah, go right here. So wait, hold on. Cancel. I might can't share my email. Oh, yes, I can. Look. That nigga sick, man. He wish he never seen a fucking Dolph. He wish he never seen young Dolph. Yeah, they gonna mess him up, man. Yeah, he been fighting for his life. Coke figure paid my nigga Odom people $10,000. I swear to God. Coke figure, the YouTube man from Texas, he sent Odom nephew a cousin or something, or little brother, $10,000 because he beat Straight Drop. I'm not making this up. That man got $10,000 and sent it to Odom nephew for beating him up. He have been fighting in there a lot. He said he been fighting for his life. I ain't lying. I know everybody who got something to do with Dolph. Even people out of other states, I know everybody that damn near got something to do with Dolph. Co-figure, that nigga sent $10,000 to my boy Odom, nephew, bro. I'm finna show y'all Odom. For real, for real. I was all down there with Odom too. I gotta go back down there. See, if I go down to Memphis, man, there's plenty of bread out there.
Basically, the mirror, I feel like it was his dude. I feel like I just.
He the one who put the mirror up. This my homie.
If you look at the past or whatever, I feel like he won't want to know where else but it. On every CD, everything he ever did, he mentioned his dude. You know what I'm saying? So when I was thinking about it, I'm like, look, man, I'm stamp this shit.
This Odom right here, the nigga, his nephew beat the shit out of what's his name in there, and co-figure from Texas sent them $10,000. I swear to God.
Behind his artistry, you know what I'm saying? Behind his music, you see what I'm saying? So when I was thinking of the mirror, I didn't want nobody else to really like get creative and put it somewhere that he won't feel comfortable or exist. So anytime.
This is a good brother, bro. He took the money out his own pocket. Ain't nobody paid him do that. And he paid the artist man who made he cold. He make all they album covers and he cold with That's why you look at the mural, it kind of look like his airbrush dude cold with the airbrushing. This one artist. I think I met him. I don't know if I met him or not. But I think I met him before. Because everybody be telling me about him. Slow-mo, all of them. But yeah. This is the guy behind the mural that's in Dolph Land.
So what better place than, right here where everything started was on boards. You know what I'm saying? So, that's what I did. That's what I did. And I know, you know, the universe protecting me because guess what? Like I put it on Google, you know, Google search or whatever, we get over 20,000 views a month. And it's constantly growing. You know what I'm saying? Like 28,000, really 28,000. Minimum probably like 20. There be people from all over the world. It's really a tourist attraction. You know what I'm saying? Like there be people from England, there be people from everywhere around the world, Africa, whatever. They come right here to our neighborhood to take a picture. And some people just be passing through Memphis. You know what I'm saying? They just come through. It's like the King Von mirror or whatever. You know, the same exact thing. You know what I mean?
But a little bigger to me.
It's a little bigger.
The Dolph mirror is bigger than me.
Yeah, I believe it's kind of bigger because, you know, Dolph.
There's this original one on the stove.
Yeah, it's the original. Yeah.
Yeah.
Yeah, I feel like, yeah, you know, Dolph just put in more work. Like, R.I.P. King Love, but Dolph just, he more of a grown man. You know, he got his stamp in the streets and the music. You know, he been doing it for a long time. So, you know, and plus he got a whole, you know, like, business as far as, like, company as far as paper writing. You got artists too, so, you know, of course it's going to be big because you got more people that's really just pushing behind him. You know what I'm saying?
Do you have any pictures of that?
If y'all ever in Memphis, y'all come down to, you know, Dolph Mirror. All you gotta do is Google it on Google search. Type it in, Dolph Mirror Memphis. It's gonna pop straight up.
Yeah. That's what it is, gang. I don't want to hold you too much. I appreciate you telling me that, gang.
Okay.
All right, gang. I'm silly as hell. If the one in Castelia still up, right? I need to go back down there. We need to go back. I need to go back to Memphis. Then I need to reiterate. I got this. But see, I lost my channel. But this is the perfect time to drop this documentary, though. I ain't gonna lie. Then we still got Govin Trial. And then we still got Cornelius Trial. They gonna put his ass in the paint. The most lenient one, I think, is gonna be straight drop, Govin, and then the worst is gonna be that dude. But I want to see because they running into overtime now. Jury deliberation and trial for murder of young Dolph. So man, we need to stay tuned. We finna keep our shit going. We waiting on this trial. We all here together. We done covered Larry. We done covered Larry Hoover. He go to court back on the 7th. He got 11 more days to know what they gonna do with that. We covered a lot of little things. We covered a lot of stuff today. This was actually a good live. I had my one of my originals come back. She showed me the house. Let's see if I got her footage. Let's see what we got of her. Cause she was the one when I first went down there. I linked up with Dolph now, and then I got up with her to show me where the thing was at, the where they parked the car at. She took me to where they parked the car at. So I need to find that. She definitely took me to where I parked the car at. I mean, not where I parked the car at, but where they parked the car at. And we left Dolph and them and went over there and hollered at her for a second. I was like, I'll be back. I wanna, you know what I'm saying, go see this one spot, the fans, you know. I went and did it. Now this the school and shit. This the school I think Dolph was trying to buy. I got so much shit in here, dude. It's ridiculous. I got 5 trips of Dolph. That was damn near the last. Nah, that wasn't even the last trip. I got so much shit I owed them. This is my last time hollering at my home. I got a lot of little shit in here. I got they homie who a pal. I got a lot of people in here. Okay, this that. This one it's way before this. This crib, this going into white folks. I need to just take all this shit and just put this shit on the timeline. Who is this? That's G-Mac. Here go. This us in Chicago. We all over the place for Dolph. We all the way in Chicago.
Well, the beginning.
This the beginning?
Yeah, well, Dad and Mama met.
Look, we all in Chicago.
Yeah, 7946. Where young Dolph played as young.
We all in Chicago. This Dolph crib in Chicago.
First girl in my house. It's your first day.
M-Town. This Dolph crib in Chicago.
His mother-in-law, they husband used to fix cars in the back right there. We sit right there, right behind. So our garage was just linked up, and they fixed cars together over there. You know,
this is how his mom and his dad met.
Where we at? 78, well, 79th and left. We still on 79th and left. I'm finna get a little closer.
There's a lot of shit in here, man. I got a lot of shit in here, man. I think I'm trying to find the house. These same things was sitting right here, Papoose. Was these flower pots was right there? This the original. Ain't nothing changed. This light and stuff is still here. Alright. See, I'm cold. I know the most about Dolph. Y'all go tell all them phonies, old man, all y'all was lying, just getting money. I know y'all wish I was with Ghetto DVD now. All y'all fake and phony people. I know y'all wish y'all, because I'm finna put in my channel bus on documentaries. I'm finna be up for a couple of days on this documentary. Let's see. With they shiesty ass. Didn't they dip on me, G? Look. Look, my shit busting on documentaries. My Dolph should get 1 million views. If I put that shit together right, it's gonna come together. I gotta see his auntie who he really loved unpassed, bro. The one who spoke up there at the thing when they named the street Dolph. I'm telling you. Let me show you. Like this 600 documentary got 50,000 views. I'm finna put that Dolph doc. I got some work to do, dude. That shit gonna take forever. Cause I done got so much to it and deep into it. It's like a real fucking movie. I know my documentary at least gotta be an hour or two. At least. You heard me? All me filming, all real people. I could keep pulling up real motherfuckers who knew Dolph. Mm-hmm. She passed. Dolph love her. Yeah, I'm telling you, man. Nah, I gotta just wait. I'm trying to get my money tight. You know, I don't like coming down to Memphis without no money. You feel me? We can't have no drinks or nothing. You know, eat. You feel me? Ride. Need a car. You know what I'm saying? So I gotta wait till my money get right. I'm right back down there. I'm messing with my same people. You could show me some more. I'm putting some of your video in a documentary or you on the scene. See, I got exclusive people like that in Memphis. Like, I couldn't get it because niggas was bombing my photo. Fred, the sport man who do sport photography, he sent me the thing where I was at. He sent me the photos I couldn't get. The ones I didn't have, he had. I gotta get him credit in my DVD. Shout out to Fred. He do the sport photography and he worked with the Little League, the football teams and shit. He do photography. He sent me this. This is what Fred sent me. I ain't gonna try to spoil you the thing, but you know I gotta keep y'all entertained, man. I gotta show y'all a little something. Y'all don't know how it's gonna come. See this. Here go, dude.
For those who don't know me, I am DJ Rocksteady. I was Dolph's DJ from the beginning.
I know him.
I was a DJ for over a decade, and these streets right here in this community made Paper Route Empire. It birthed Paper Route Empire.
This is what I want y'all to know. You feel me? I've been there since the jump. I've been there since the start with Dolph. I've been there since the jump. And this the thanks that I get. This the thanks that I get. This the thanks that I get. We been here from the jump. And this the thanks that we get. One person in our life. This the thanks that we get. This the thanks that we get. This the thanks that we get. When we said that shit, when they said PIE, FLE for life, I meant that shit. When I said that shit, I meant that shit. I wasn't playing. Look, man. When I said that shit, I meant that shit. When I said FLE PIE for life, I meant that shit. Being around them brothers and being around a real record label and a real music, I feel like my shit's still going somewhere. Because I could just bust out and go to Memphis on y'all ass. And they love me in Memphis because that's all I talk is music and film and rapping. That's all I be talking about. I don't got nothing else to talk about. I love Memphis for that, bro. Now, I don't like, now y'all good with the music, but this gang stuff and y'all trying to get that started and that straight drop did that, bro. Like, Memphis wasn't nothing like that shit until they killed Dolph, dude. I don't like that. I'm used to Memphis being fun. Memphis motherfuckers, you think bro got a gang of money. I wish a motherfucker, that's the Memphis I know. You could get some money out there. Only thing I don't see how they making money off
off that meth shit, you get them one rock, they high off for 2 or 3 days. So how many people is buying this shit to see some money? Cause one month, ain't they high off 2 or 3 days when they take that meth? Don't they be high 3 or 4 days? I just want y'all to know, man. Ain't shit gonna be handed to you. Ain't shit gonna be handed to you. If you ain't got the funds to do what you wanna do, these niggas out here gonna make sure you don't have the funds. So you won't be able to lead them up. They don't wanna see you getting they don't wanna see me getting no money. Cause I only need about $10,000 to polish me up. Get me around them right people to take off. See, they ain't gonna hit my cash app. They ain't gonna want because they know I'm that close to reaching where I'm going. They know that, bro. You can look at me. You can tell what I'm doing. I'm that close. So niggas don't want a nigga to get that close, gang. They ain't gonna do shit because they afraid that you gonna beat them out, man. I ain't come out here this cold. I did this shit for Dolph. For real. You know how much money I could have kept for myself? No, I went to do this shit for Dolph. I did this shit for Dolph and them people. I did this shit for myself. I ain't look for shit in return. But I would like for you guys to hit my subscribe button or hit my motherfucking like button. This shit ain't free. These likes and this shit ain't free. Doing this shit. It's cool. It's hot as fuck in Memphis. This shit ain't free. To edit all that shit ain't free. I can't do that on no funky ass laptop. That shit ain't free. But I'm gonna keep doing it, man. I'm gonna keep going as long as I got it, man. As long as I got it, y'all got it, bro. As long as I got it, y'all got it, bro. But I'm really waiting on this motherfucking verdict. They gave them some more because they almost had it. They giving them some more, they giving them some more time. They buying their ass some more time, basically. Cause to be honest, court is over with at 5. Court is over with at 5, gang. Court is over with at 5. So how long is we gotta wait? We might not have to wait that long. I need to go plug my phone up.
Yeah, I'm right here. Hold on, let me milk this. Hold on. Might start back up. Yo. We here. Wait, hold on. Yeah, we here. We here, man. We waiting on this verdict. We ain't going nowhere. It's a waiting game. Damn, it's a long ass live I've been on. It's a long live. We waiting. It's 4:05, man. We waiting on this live, man. We've been out here too long, man. We've been too long with it, man. We've been too long with this, man. Well, I'm finna take me a quick recess because I need to do something real quick while we wait on this verdict. Soon I'm right here standby. I got a plan. I'm right here on standby.
Good evening, everybody. We're breaking into programming right now as the judge in the trial of Justin Johnson, that's the man accused of killing young Dolph, has reached a verdict. Now, this is a live look into the courtroom right now as the jury has made its way back into the jury box there. Justin Johnson is facing several charges in the death of young Dolph. Johnson was one of 3 people charged, but he's the only person on trial right now. The jury can find Johnson guilty or not guilty on 3 different charges. Number 1, conspiracy to commit first-degree murder, 2, first-degree murder, and the third, a convicted felon in possession of a firearm.
They finna give out the verdict, I think. I'm right here.
Ladies and gentlemen of the jury, have you reached a verdict?
Yeah, Your Honor.
Four person. If you would stand and read your verdict, please.
We, the jury, find the defendant guilty of conspiracy to commit first-degree murder as charged in count 1 of the indictment. We, the jury, find the defendant guilty of first-degree murder as charged in count 2 of the indictment. And we, the jury, find the defendant guilty of convicted felon in possession of a firearm as charged in count 3 of the indictment.
Thank you. Juror number 1, is that your verdict? Juror number 34, is that your verdict? Yes. Juror number 35, is that your verdict?
Yes.
Juror number 11, is that your verdict? Yes. Juror number 14, is that your verdict?
Yes, ma'am.
Juror number 17, is that your verdict?
Yes, ma'am.
Juror number 27, is that your verdict?
It is, Your Honor.
Juror number 33, is that your verdict?
Yes.
Juror number 25, is that your verdict?
Yes.
Juror number 44, is that your verdict?
Yes.
Juror number 23, is that your verdict?
Yes, ma'am.
Juror number 28, is that your verdict?
Yes, ma'am.
Thank you. Ladies and gentlemen, I want to thank you again for your time and attention to this matter this week. Our system of self-government would not work without your service and sacrifice that you've made. Thanks again for your time and attention. You are excused.
Jurors excused.
And once again, there you just heard the verdict of the jury in the Justin Johnson case, the man accused of shooting and killing young Dolph. He's found guilty on all 3 counts there. Count 1 of that indictment, the charges, conspiracy to commit first-degree murder, lesser offense, facilitation, to wit, conspiracy to commit first-degree murder. Count 2 of the indictment, first-degree murder, lesser offense, second-degree murder, facilitation with wit, first-degree murder, facilitation to wit, second-degree murder, voluntary manslaughter, aggravated assault, facilitation to wit, voluntary manslaughter, facilitation to wit, aggravated assault, simple assault, facilitation to wit, simple assault. And that third count, convicted felon in possession of a firearm, as you heard right there. Each one of those jurors agreeing to a guilty verdict in this case. Now, we will have more to come with this case. There will, of course, be much more to follow. ABC 24 News will be on top of this. As we've told you, we were covering this case gavel to gavel, just 1 week to find Justin Johnson guilty of all charges in the murder of Memphis rapper Young Dolph. Stay tuned. We'll have more.
Well, we waited. He got found guilty on all 3. His lawyer wasn't shit, man. I'm telling you. His lawyer wasn't shit, G. Hold on. Let me present the screen. He went back in. His lawyer wasn't on shit, man. He finna go smoke him a square. That state's attorney man was fucking him up. That state's attorney man came in like a real lawyer today, boy. It's over with. Over with. Bang, 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 man. We watched it, man. We sat here 6 hours waiting on this shit, Jay. Me and M-Town. And folks, them, 2 of the folks came through here. Me, M-Town, and Larry. Larry people held my live down today. I appreciate it. M-Town, she showed me the house where they parked the car at in this infamous crime. I got to go through my footage. I got it. We need M-Town and we need Larry and them people to keep sticking together, and we don't keep sticking together, man. Y'all all I got, bro. And a few Chicago ones, but mostly Memphis, because y'all about business. And y'all got a good, kind heart up there, man. That's why this shit, they did this shit on purpose, I think, to destroy y'all community and y'all music out there, because that's what y'all really got going on out there. Something. It was just criminal acts. But, man, though, we going to hold it down. We going to stick together, man. Larry next court date is the 7th. So y'all tune in with me, man. I'm finna. You say get this documentary together. She want her film in there. Yeah, I got you. I gotta put that together now because they still got 2 more trials. They found him guilty. So I gotta work on that this weekend and this week. So the rest of this weekend and shit. So all right. So what I'm gonna do is I got a few things I need to make. And then I gotta get straight to that documentary. But I'm gonna tap back in with y'all like in a couple of hours. But I've been on here 6 hours. I need to take a little break real quick. I'm gonna come back in. Y'all got me. Y'all gonna find on IG either my number. If y'all one of my originals, y'all should have my number. Like M-Town, she got my number, bro. She found my number. This is my second phone. I would have never had her number. I had her number. I had so many people number in my phone. I could just type in Memphis, and then everybody number pop up. I didn't have her number no more. I got Fred number. I got Fred number. Got Papoose number, Slow-Mo number, South Memphis number. I got that lady who was in that black dress number, who got me into the to Dolph second homecoming. She like she was working with the mayor or the alderman or something. She's some type of political lady. And now I got M-Town. I got her back. So man, I need to get my fans back, man. Y'all see my fans out there, tell them like, man, Ghetto looking for y'all. When y'all see my fans, say Ghetto channel. They took his channel. He got a new channel. He up and running. Y'all go tell my fans. But today, a lot of people tuned in to me. I seen my numbers going up. So y'all let the fans know I'm back down, and I need to get this documentary together because there's people that's really a part of this. It's a lot of people that's really a part of this shit and that's really in it and really probably want to see themselves in a documentary. So I need to get this together. I had prolonged it because I wasn't gonna put it out and I ain't had nobody to show it to. I ain't had no fans or nothing. So my channel back busting. Then Memphis coming back. They slowly finding me back. People calling me back. White folks been on my coattail this whole year. White folks been telling me, come to Memphis. You gonna take me to Wicked, all that. So, man, I just been kind of down because my YouTube been down, man. I'm giving y'all truth, man. I ain't got a lot about nothing, man. I ain't no fake person. I've been down this year. So last year I wanted to work in Chicago to get my name up. So when I get back to Memphis, I at least have some subscribers and shit. So now my shit up. Now it's time for me to get back to Memphis and finish what I was doing in Memphis because I ain't want to go down there and need them to help boost me up. I'm boosted already. So now, you know what I'm saying? Now I feel good going down there at a certain level. You feel me? So y'all know how I go. But yeah, bang, bang, bang. Get money gang. I'm gonna be back in like 3 hours. And y'all share this live. This was a dope live. I sat on this bitch 6.5 hours, gang. Straight up.